Good morning, everybody. Welcome to the Interim Judiciary Committee. Thank you for bearing with us as we got started. Let's go ahead and have our esteemed secretary please take the roll.
Senator Krasner,
Here.
Senator Nguyen, Assemblymember Cole, Assemblymember Gonzalez, Assemblymember Marzola, Assemblymember Miller, Chair Scheibel.
I am here. Please mark those members present who are not here yet, present when they arrive. I know everybody is making their way to the committee room. We have a packed agenda today, so we are going to jump right into it. I have received a little bit of feedback about the length of these meetings and the timing of the presentation, so I will be a little bit stricter today, ensuring that everybody sticks to the 15-minute guideline. I understand that you have all been warned about before coming in here today, so I know that we have really good discussions here, and I very much enjoy that and appreciate it, but we got to keep things moving, so I may cut you off at about 15 minutes. As always, we ask that you silence cell phones, pagers, beepers, things like that while you're in the committee room, but also please be cognizant that those of us up here on the dais are utilizing them to access meeting materials. We try to be as paper-free as possible and encourage you to do the same by logging into our website to access any meeting materials. If you are here to testify, please sign in at the table at the back. Same thing if you're going to give public comment. It looks like we do have a number of people here, so I will also go over kind of the format for testifying in case you're unfamiliar. We always have a presentation first, then members of the committee are allowed to ask questions, and then we wrap up after that. When you are testifying, you do have to turn the microphone on in order to speak. And we ask that during the question and answer portion of the presentation, you say your name before you speak so that our minutes will reflect accurately who was speaking. I think we do have some members on Zoom today. I think we'll also have some presenters on Zoom today, as well as those of us who are in person. I think those are all the housekeeping items that I have. So we have 2 opportunities for public comment in interim judiciary, one at the beginning of the meeting, one at the end of the meeting. So let's go ahead and jump into public comment. We limit public comment to 2 minutes per person. And we will start with anybody wishing to give public comment in person in either Las Vegas or Carson City. I don't see anybody coming to the table in Las Vegas, so we will start in Carson City. Please go ahead when you're ready.
Good morning, Chair Scheibel, members of the committee. Tanya Brown, TONJA, BROWN, advocates for the inmates and the innocent. We have recently submitted our recommendation to this committee and the material. We are asking for your support on a recommendation for consideration that's before you. Right now, Nevada has no legal path to correct a wrongful conviction once the person has passed away. The Nolan Klein Act fixes that. It creates a posthumous factual innocence petition, provides symbolic compensation and restorative rights for families, and requires mandatory open file discovery from both law enforcement and district attorneys from arrest through trial, appeal, post-conviction, and even after conviction. This bill strengthens the transparency, accountability, and public trust. It ensures that public justice does not end a person's death and that the truth can finally be heard. I'm asking for your support on this recommendation. My member on our board, she should be dialing in, I think. She's actually coming in next month, and we're not sure on whether or not we're going to be giving a presentation. Nobody has said anything, but so I just kind of want to remind you that we have provided you this information. And then back in 2017, or actually 16, the ACAJ had acknowledged that anything coming through a public comment, it's been vetted and so on and so forth. The recommendations can be accepted that way. And also, I just want to let you know, if this Nolan Klein Act passes, it will set a precedent for this country. Nevada will be the #1 leading state in justice reform. Thank you.
All right, I don't see anybody else coming forward to give in-person public comment, so we will go to the phones, please. AVH, do we have anybody online or on the phone to give public comment?
Thank you, Chair. The public line is open and working. However, there are no callers at the time.
All right, thank you so much. That takes us to the next item on our agenda, which is approval of the minutes from the January 13th meeting. All of the members, I believe, got a copy of these minutes. Are there any questions, amendments, issues with the minutes? Not seeing any, I would accept a motion to approve the minutes. All right, I'll take the motion from Assemblymember Marzola and the second from Senator Nguyen. Any discussion on the motion? Not seeing any, all in favor say aye. Aye. Any opposed? Nay. We've done a great job unanimously passing the minutes from the January 13th meeting. And with that, we can move on to agenda item number 4. We'll be hearing from the 8th Judicial District Court. Please come on up and get started whenever you're ready.
Good morning, Assembly members, senators. My name is Jerry Weiss. I am the Chief Judge of the District Court for about the next 11 days. The reason that we're here, I've been able to meet with many of you for the last 2 legislative sessions. I won't be the chief this legislative session, but last session we had a bill where we were proposing or seeking additional judges for the 8th Judicial District Court. It was based on a Delphi study, which was an internal study that we did with our judges. One of the things that we talked about when we made that presentation to the Assembly Judiciary this last session was that we heard comments from the Assembly members. We let you know that we were in the process of doing a full-blown weighted caseload study, and we were asked that once that study was done, that we come and present that to you. That's why we're here today. I'm hoping that we can educate you and help you understand what the need is and why we have the need for additional judges. I have Shannon Nguyen from the National Center for State Courts. She is the one with her team that did our weighted caseload study. And I'm going to turn the time over to her so she can explain what the study is, what it means, and what it means to the future of the 8th Judicial District Court.
Thank you, Judge Weiss. Hi, I'm Shannon Nguyen with the National Center for State Courts. And I am here just to give you an overview of the project we did and the project methodology and the ultimate results of that project. So a weighted caseload is where we go into a court and we measure the work of the court, and then we assign what we call case weights or average case processing times to account for the complexity varying between the case types. And then ultimately we develop a model that says how many judicial officers are needed to handle that workload. So we basically convert the caseload of the court into workload, and then we look at the type of work that judges are doing, we identify and measure that, and then we use that workload again to determine the number of judges needed. Again, the case weight or average case processing time, we use this method because you can't use just filings to measure the workload of a court because, again, the complexity affects the time it takes to process a case. In other words, volume does not equal time. For example, you can see with the blue graph, there are a lot less misdemeanor filings in this example than there are traffic cases. So you might assume the bulk of a judicial officer's time is spent on the traffic cases, but is actually, when you look at the average case processing time, a misdemeanor takes much longer. So in reality, judges may be spending more time on misdemeanor cases, even though there are a lot less of them. So the steps of the project, we met with an advisory committee at the beginning of the project to set up the parameters and make some decisions. We conducted what we call a time study, so a time and motion study, to get a snapshot of current practices of how judges are processing their cases and how long it's taking them. We also followed up with a qualitative piece, an adequacy of time survey, where we sent that out to all judicial officers in the 8th Judicial District and asked them, how do they feel? Do they feel like they have enough time? Are they stressed? Are they working weekends? Then we brought all that preliminary data back to the advisory committee, shared that with them, and then we conducted a follow-up qualitative piece with focus groups. So we actually spoke with judicial officers and really delved into those survey results and had conversations about how they felt and obstacles and that kind of thing. Then we had a final meeting with the advisory committee to bring everything back together and make some decisions, and then of course develop that final model and final report. So during the process, the advisory committee's role was to provide guidance to us on the court. We are the weighted caseload experts, but they're the experts on their court. So we asked them to help us set up the parameters. They decided what case types we were going to collect data for, what activities. They helped us determine how long the time study would be, which it was 6 weeks that we collected data. We also asked them to market the project to their colleagues because one of the key things is we needed good participation. And then we asked them to review the data, the findings, and of course, make any adjustments based on those findings as needed. So we had really excellent participation during the time study. We got 96% of judicial officers out of the expected that were supposed to participate. And this gives us a lot of confidence in the data. We feel like we got an accurate reflection of what is currently going on in the 8th Judicial District Court and what judges are currently doing. So the thing about the time study, though, is it is a snapshot of current practice. It shows us how judges are currently processing cases. It doesn't necessarily reflect how it should be. Again, if judges are working weekends, if they're working overtime, if there's stuff they're prioritizing and other stuff is getting set aside, this isn't necessarily how it should be. So we did follow up with that qualitative piece. And the first part we did was that adequacy of time survey. We sent that out right after the time study to all judicial officers in the 8th Judicial District. We asked them about their perception on whether they feel like they have enough time to get their work done to their satisfaction, and also if there were obstacles or anything else that affects their case processing. The survey itself was a combination of Likert scale, multiple choice, and open-ended questions. We then followed up with the focus groups. We did have 2, and we met with both judges and commissioners to really dig a little bit deeper. We asked them about the data collection period, the time study, whether they felt it was representative and reflective of their work, whether there was stuff that they didn't feel like they recorded, so anything that we were missing. We also asked if there was anything that impacted their case processing, like any kind of case complexity, any kind of legislative changes, anything like that. And then, of course, we followed up on that survey data and asked if they felt like they had sufficient time to complete their work. So once we had the time study data and that qualitative piece, we could start putting it together so we could calculate the workload of the court, and then, of course, ultimately calculate that need. To do that, we needed the filings from the court. We also needed the case weights, those average case processing times, which we developed from the time study data. And we needed what we call a year value, which is just the number of days that a judge has available throughout the course of a year to process cases. So we got the filings, we worked directly with court administration, and we actually got a 3-year average. So we got fiscal years 23, 24, and 25, and we developed a 3-year average instead of using a single year. The reason we do this is it allows to smooth out fluctuations in the filing data. So, and we do recommend this for every project that we do, is to use a 3-year average when calculating these case weights. So then we needed the case weights themselves. To do that, we took the data entered during the time study by all judicial officers. So in this example, we're using divorce cases. So those minutes, that 122,000 worth of minutes, that was all judges during the time study that entered time for judicial cases, or I'm sorry, for divorce cases. We then divided that by the number of days, working days during the time study to get a daily average worth of minutes. So in this In this, it's 29 minutes because or 29 days because there was a holiday during the time study. It comes to a little over 4,000 minutes per day on average that judicial officers are handling divorce cases. We then multiplied that by the year value, which here it's 220 days, and I'll show you exactly how we arrived at that number in a minute, but it is taking out weekends, it's taking out vacation. And the reason we do this is while judges probably are working weekends and not taking vacation, we want to build a sustainable model. We don't want to build it so that they have to work every single weekend and they're not taking time off. So 220 days, we multiply that to come up with annual minutes to handle these divorce cases. It comes to a little over 900,000 minutes. Once we have that workload, those annual minutes, we can divide it by the annual case filings, that 3-year average, and come up with that average case processing time. And for divorce cases, it was 77 minutes on average. It is an average. We realize cases are going to take longer. We realize some are going to take shorter. Some judges might only touch for a few minutes. And it is just the time a judge is actively working on a case. It's not from filing to disposition. So I know this is a little hard to see. We could certainly share this later, but these are the final case weights. We took these back to the committee preliminary and then after those qualitative results and discussed possible adjustments if anything needed to be adjusted. The committee ultimately adjusted or accepted all the case weights with no adjustments. So these are the final case weights for all the case types that we collected data for during the time study. So now that we have the case weights, we can start calculating that workload. The way we do that is we take the filings for each case type and we multiply it by that case weight, that average case processing time, to come up with a workload for each case type in minutes. So you can see case type A, for example, 1,000 cases multiplied by 240 minutes comes to an annual workload of 240,000 minutes. We then add all that up and we come up with a total workload for the court throughout the course of the year. In this example, it's 480 minutes. So we have the workload, we have the case weights. Now we need to determine how much time does a judge have available to work on cases throughout the course of the year. So this is how we arrived at that 220 days. We worked with the committee to take out the weekends. We took out 12 state holidays, and then we took out time for vacation leave, sick leave, any kind of other leave, which came to 220 days. We then came up with the amount of time during the day that judges have available to process cases, because judges have other things that pull them away from their casework. They have case or non-case related administration, they have personnel issues, they have meetings, they have legal research, they have work-related travel. So we have to account for all of that time that is pulling them away from time to process their cases. So it came to roughly 6.3 hours per day that judges are able to work on cases. This is data that came out of the actual time study, so it's actual data. When you multiply that by the 220 days, it comes to almost 83,000 worth of minutes that judges have available throughout the course of a year, a single judge, to process cases. So then you take that value, that 82,786 minutes, and divide that into the workload for the court to determine how many judicial officers are needed. In this example, it comes to 5.8 judges. So that's how we determine the workload and then the number of judges to handle that workload. So in the 8th Judicial District, we did the same thing. You can see in the first column, we have those case weights. We multiplied it by the filings that we got from court administration. And then in the third column, it is the workload for each case type throughout the course of a year on average that judges have to process these cases. So once we have the workload for each case type, we total it up and it comes to a little over 7 million minutes worth of work throughout the course of a year. We then have that year value, that 220 days per year. We take out time for the non-case related work. So again, that committee meetings, non-case related administration, personnel issues, we take that out and we take out work related travel. And again, these numbers that you see, this is actual data that came from the time study. So it's an average of the non-case related time and travel that judges were spending during that 6-week period. And then we annualize those minutes to come up with this deduction. And then we come to that 82,786 minutes available again per year for judges. You divide that into that 7.2 million minutes worth of workload, and you get a need for 87.31 judicial officers in the 8th Judicial District. They currently have 58 district court judges, and they have 15 commissioners. So they have a total of 73, which leaves a need for 14.31 judicial officers. I would like to open it up for any questions or comments at this time.
All right, thank you. We'll start with Senator Nguyen.
Thank you for that presentation. I just have a couple of questions. One, I'm going to start off with, you had indicated that there were about 29 days per year that each judge was taking for vacation or sick leave. Is that on average, or are there outliers on either end of those, like, numbers?
So that is an average, and it is actually—
I'm sorry, I have to remind you to say your name before you speak every time. Sorry.
Sorry about that. Yes, Shannon Nguyen. That is an average, and it is actually on the lower end in comparison to many of the other studies we do. Typically, there is 30 days of leave and also like an additional 10 days for any kind of other training or military leave or bereavement or anything like that.
And if I'm not correct, just to put on the record, judicial officers are elected judges because they are beholden. They don't have like a set number of days. I mean, you do have some judges that I'm sure are on the like higher end, you know, whether it is by choice or by like circumstances of health or any of those kind of things, that they have unlimited, I guess, PTO days, as most people would. Isn't that correct?
Shannon Nguyen again. I think it varies. It really does depend on the state or the jurisdiction that we're dealing with. So the way we determine the leave when we're determining the year value is it's, again, sustainable. So we realize that some judges aren't going to take it at all, and others might actually try to take a full 30 days if they can.
I guess I'm sorry to interrupt you. I understand where their averages are potentially coming from, but if a judge that is elected wanted to take off 6 months, they could take off 6 months.
Jerry Weiss, when I first got elected, I asked how many vacation days I got. The answer I got was, you can take as much time as you want. If you take too much, it ends up in the paper.
Yes. Okay. That's really what I wanted to clarify. I know there was a lot of communication amongst committee members about how much vacation time or how much sick leave or how much PTO or how many vacation days. And I just wanted to clarify for the record that there isn't any set number. It's really up to the discretion, and the voters can respond, in kind. I guess my second question is do you have the number of days that you've had to call in senior judges or that other judges had to cover for that? Is that in alignment with the number of days that these judges are taking off? Or because I know part of your budget is accounting for those senior judges to cover when judges are out. So I'm curious on how much, how much of that is taken into account.
Jerry Weiss again. I don't know that I can accurately respond to that, but I can tell you my experience is that judges will sometimes ask for a senior when they're gone on vacation or something like that. Other times, we will not use a senior. We'll ask a buddy judge to cover for us. Sometimes judges will ask for a senior to come in and do a settlement conference simply because it's the parties have asked for a senior as opposed to going through the regular settlement conference program that we have. So sometimes we'll have seniors come in, even though they're not covering for a judge. They will handle settlement conferences and things like that for the judge while the judge may be in trial. So I don't know that answers your question completely, but I don't know that there's a real easy way to answer it.
I guess I'm just looking for some additional data. Obviously, you provided a lot of like statistics on the number of hours that judges are working and kind of breaking that down. So I'm just curious on what kind of statistics you cover when, when a senior judge is called in, when those kind of resources are utilized to kind of alleviate some of the natural, like vacation days, natural conference days, natural like things that happen during that work week. So if you do have any of that information, obviously you probably don't have it offhand, but I would love to be able to see that. And I'm sure the committee would also be interested in that, because I know it comes up during like money, when you're asking for money, when you're asking for raises, and we're asking to fund some of these programs. So I think that would be helpful. I think the second question that kind of stood out for me is you had talked about how long cases take and how long they stay. How much of that is accounted for by the time it takes individual judges to make decisions on motions or to move cases? And how much is that has to do with scheduling?
Shannon Wynn. So the time study is, like I said, it was a 6-week snapshot where we had judges record time for case types and activities. So we actually had them record whether it was like pre-trial, post-disposition, whether it was actively a trial. And what we got was from across the court. We got pieces of this pre-trial over here and post-disposition over here. Maybe another judge had a trial. So we were able to see how long judges were spending currently for the different pieces of the case. So it does take that into account. Again, it is an average. So some judges, again, depending on the trial, it could take a lot longer, it could take a lot less time, and you have to factor in tenure as well, experience. But what makes it accurate, what makes the average good, is because every single court is going to deal with that. They're going to have inexperience, they're going to have very experienced, they're going to have those long, complex trials, they're going to have those trials that settle or that they plea. So that's how it's taken into account, though, which is why the participation is so important, because we want to get a snapshot of all of that from across the court.
Is there anything that you do utilize when you look? I'm sure in that snapshot, you are very well aware of judges that maybe have more experience or have are better at managing, I guess, their caseload, better at managing decisions. Is there anything that you are doing to utilize, for lack of a better term, the better judges are the more experienced judges at moving cases along and handling cases, to mentor either new judges or, I mean, what are you doing internally? And I realize that you're dealing with a big group of judges that are independently elected in their own right. So I'm curious on what kind of programming you're doing to utilize the best practices of those that are doing this well, that maybe are able to move cases in 1 year as opposed to 3 years.
I'm assuming that question is for me. This is Jerry Weiss. Obviously, we have constant influx, right? We just had Colleen Brown is starting. Pete Tennell was just recently appointed, and then so some of these judges are brand new. They obviously have a background. So each of those people that I named have a criminal background, right? So they're going to come in and be able to do really well on criminal stuff. If we can give them an all criminal caseload, that's fabulous. Usually we would have to give them some kind of cases that they aren't familiar with. So they may end up with a split docket doing civil and criminal. In those cases, we ask them to find a buddy judge, somebody that they're more comfortable with. If we assign someone, we find that they don't generally go to that person because they don't know them. So we ask them to find a buddy judge who's more experienced in the kind of cases or the kind of case type that they're assigned, and go to them with questions. We find that generally works better than assigning a mentor because sometimes they're not comfortable with their mentors and they won't ask them questions. Does that answer your question there?
It does. I'm just curious I guess, like to see like evidence-based like practices as best as we can to encourage this. I mean, you could conceivably have someone who like is going to someone who's, I guess, for lack of a better description, teaching them bad habits, but they're friendly. So I'm curious on what other jurisdictions do and what other states do to encourage, like, I guess, better judicial training to alleviate some of these roadblocks that we have in moving cases along quicker.
Yep.
Thank you.
You can answer.
Hi, Shannon Lynn. Yes, so there are some states that have different type of mentoring programs, and they also, we've done case flow management or court performance studies, that kind of thing, to help with this type of issue. I do have to say, though, when I was working with the 8th Judicial District Court and the committee, I could tell that the judges, at least the ones on the committee, were very experienced, very specialized in what they do, and they worked very well together. They were a very cohesive group. So while it might be an informal process that they use, I saw signs that it worked very well, at least in my personal opinion.
I don't have any other questions at this time, Chair. Thank you.
Thank you. We will go to Vice Chair Miller.
Thank you, Chair. Thank you for your presentation. As we know, this was a bill that was presented during regular session last session, and we had some of the same questions and concerns and challenges. And so, you know, one of the most basic questions when it comes to this issue is that, and I will preface this by saying that we know that I always say narrative speaks louder than policy, meaning often our reality is, you know, true to us as individuals. But as legislators, we often hear from not just the community, but from many other professionals that interact with judges as well, that the hours that are worked, the days that are worked, the accessibility of getting a hold of judges whether we need judges for a warrant or for dockets late in the afternoon. But we continue to hear from many other professionals in the justice system that the hours and the days that are being worked are not as it's being presented here. And so we also are people that we continue to be engaged with our community. We knock on doors. We talk to community members all the time. And when community members are asking for more of a certain profession, they're asking for more healthcare providers, they're asking for more educators, and even they're asking for more law enforcement. We don't hear from our community saying we need more judges. So I guess I would just like to give you an opportunity to respond to that. Is the reality that people share their concerns with to us about the inaccessibility of judges based on, I can't find anyone after lunch, I can't find anyone on a weekend, and balancing what is presented to us as a need for more judges? How would you suggest we respond to our constituents?
Shannon Wynn. So one thing I can say is the perception of the public as far as judges is, judges, in my experience, prioritize that public part. They're going to prioritize the trials, the hearings, anything where they're dealing directly with the litigants. So in that respect, I feel like the public is not going to say, oh, we need more judges because I can't find one, because they are available. That's their priority. The stuff that's not getting done or is being set aside or is being taking a lot longer is the stuff that the public doesn't see. It's that trial prep that they're doing at night before the trial, or the weekend work where they're having to catch up on legal research again for the trial, or they're signing orders, motions, stuff like that. The public does not see that, but judges are still doing it. So I think that's where the disconnect would be, because what they're seeing is, okay, the judges at the trial, they're doing what they need to do, so we don't really need any more.
Chair, can I have a quick follow-up? And I appreciate that because there's that perception of us as legislators, right? People believe the only time that we're working is when they see us on the dais or see us in Carson, which we also know is not true. But I just want to be clear that when it's not just coming from constituents, and I appreciate your saying that they feel prioritized, but when it comes from other professionals as well, and how would we balance, especially with budget concerns, how would we balance that with the need for other professions in the state as well?
Jerry Weiss, I guess my response to that is that one of the things that we have tried to do during my term as chief, and that I hope continues, is that we're trying to get time to disposition lessened, right? So if a case is filed, if you file a divorce case and you can't get the divorce finalized for 10 months, 12 months, 2 years, because of the backlog and because judges are so busy doing so many different things, that's a problem. And while people may not say they need more judges, if they had more judges and we were able to shorten that time to disposition, I think the community is better. If we can do a car accident case in 18 to 24 months instead of 4 or 5 years, if we can get somebody a finalized divorce within 12 months instead of 18 or 24 months, I think that benefits our community. And those are the things that maybe people aren't going to ask for more judges, but they're going to complain that they can't get their cases resolved quick enough. And those are the complaints that we hear. And those are the things that we try to work on to try to make it better for our community. And in order to do that, we need more courtrooms, we need more judges so that we can have more accessibility, more availability, so that we can pressure people. If they have a trial date, that's when cases settle. And that's really the best that we can do, is we provide the trial dates that we have. We set 50 cases on a 5-week stack. We do the best we can with the time and the resources that we have, but we really need more resources.
Okay, thank you so much.
Other questions from members of the committee? I'm not seeing any in person or on Zoom. I just have a quick question. The study went 6 weeks. What was the budget for the study?
I believe it was around 160,000. I can't remember exactly.
Okay, thank you.
Yeah, it was right around there. It was probably anywhere in between 150 and 170.
Okay. Well, we appreciate you being here to present to us today. And with that, we will close agenda item number 4 and move on to agenda item number 5, and welcome up the Nevada Department of Corrections.
Good morning. My name's Cody Castiglione, CODY-CASTIGLIONI. I'm a supervisory criminal investigator, the Office of the Inspector General in the Nevada Department of Corrections. I'm here to talk to you guys and give you an update on the implementation of SB 153 and how it's affected corrections regulations concerning the LGBTI plus community and interaction with NDOC staff. I have with here my partner, Terry Witherall. She's going to go ahead and run you guys through the timeline of how we implemented everything.
Good morning, Chairperson Scheibel and committee members. For the record, my name is Terry Witherall, TERIWITHERELL. I am the PREA coordinator for the Nevada Department of Corrections. Our implementation of SB 153 is as follows. February of 2023, NDOC initiated communications with the National PREA Resource Center to identify training opportunities in regards to SB 153. In May of 2023, SB 153 was signed into law. Concurrently, we secured an agreement with Just Detention International, JDI, a specialized external organization based out of Washington, D.C. Spring and summer of 2024, JDI conducted in-person train the trainer sessions for NDOC staff across 3 key regions: Las Vegas, Ely, and Carson City. This training focused on cultural competency for interacting respectfully and safely with offenders identifying within the LGBTI+ community. The cultural competency curriculum is now part of our mandatory PREA training for all staff, contractors, and volunteers. This alternates between in-person sessions on even years and online courses in odd years. A dedicated committee reviewed SB 153 to revise Administrative Regulation 494. This revised policy for transgender, intersex, and gender diverse individuals officially took effect in March of 2025. As of June 15th, 2026, our current offender population is 10,526. And of that population, 70 offenders have identified as transgender or intersex who are not housed in any specific unit, but across all facilities. At this time, I will turn over the presentation to Dr. Williams for the standard of care portion of SB 153. Thank you.
Good morning, Dr. Kenneth Williams, Medical Director for NDOC for the record. For clinical services, our role in the meeting the standards for the law were to ensure that we properly identified and managed inmates that were in the category of transgender or intersex. Our first step was to ensure that at intake, the individuals are identified and receive an appropriate examination. They are instructed on how and where to access medical services. They also undergo a physical examination, which is documented and includes both their sexual characteristics and physiology. Next, at intake for Medical Directive 316, they undergo mental health intake, which also ensures documentation of their mental status, as well as their sexuality. And last but not least, Medical Directive 121, which addresses specifically gender dysphoria, which documents their psychiatric needs, as well as gets a history of any preoperative experiences that they've had, their intentions, goals, plans for any operative procedures, and gathers information about their medical treatment if they are currently taking any medications for gender transformation.
All right, does that conclude your presentation? Okay, I think we have some questions from the committee. We'll start with Vice Chair Miller.
Thank you, Chair, and thank you for your presentation. I guess my main question that hasn't been addressed yet is, can you tell us the numbers of, how would I say this, for this population specifically, for the trans population that is incarcerated, the numbers of their victimization while incarcerated?
Terry Witherell, for the record, Terry Witherell. I do not have that information in front of me, but I will get you that information.
Thank you. And with that, I'd be looking specifically to see if there's a higher number and to see if Yeah, just if there's a higher number between other populations that they may be housed with.
Any other questions? Assemblymember Gonzalez.
Thank you so much. And kind of to go off of that, I'm also curious if I'm curious to your staff if the training has been helpful in understanding the needs of this population and how the training and the implementation of the training has really helped create a respectable environment for these people. Do you know, for this population, do you know if you have any of that data or information?
For the record, Terry Witherell. I do not have any feedback from staff. I will ask our training department if they have received any feedback.
Thank you. And just curious if you have also heard from the incarcerated population themselves of the impact of this training, if it really is impacting their experience while they're incarcerated with understanding their specific needs.
For the record, Terry Witherell. No, I have not.
Any other questions? I have a couple of questions, and this may be better suited for our legal counsel, but is there a permanent administrative regulation, or are we still operating under the temporary regulation from last year?
AR 494 is permanent. For the record, Terry Witherell.
Thank you. And I'm sorry, can you just walk me through then? You had a great timeline at the beginning when that regulation became permanent.
The regulation became permanent, was signed March 26, 2025.
And if you could give your name for the record.
Cody Castiglione for the record.
So can you, and I apologize, I should know this. I'm just not as familiar with the administrative regulations for the Department of Corrections. Can you describe the process that this went through in order to become a permanent regulation?
I'm not sure the process of the regulations and how they're approved. I know they go through a committee. Maybe someone up there at Carson City can answer that for us.
Dr. Williams, for the record, I can share that the first step was to form a committee that went through and looked at how other states' departments of correction were managing the issue. We reviewed standards for National Commission on Corrections and as well as ACA, and made suggestions to the director, which was then moved forward.
All right, thank you. Oh, go ahead in Carson City.
Good morning. Acting Deputy Director John Henley for the record. Chair Scheibel, to further elaborate on your question regarding the adoption of this regulation, it does get administered through the Board of Prison Commissioners, which is chaired by the Governor, as well as the Attorney General and Secretary of State in concert with the Director of the Department of Corrections. That is the final approval.
Okay, thank you. I figured it had to either be the Board of Prisoner Commissioners or the Legislative Commission. I hadn't seen it come through the Legislative Commission, and so that answers my question. I appreciate that. And what kinds of systems do you have in place going forward to ensure that the regulation is effective? Like, what kind of feedback mechanisms are built into the process?
Dr. Williams, for the record. When we have a new intake from one of the jails, we get some basic information that gives us a clue that the person that's coming in might fit this category. Then at intake, according to our medical directives for for intake, we ensure that those individuals have everything that they need. Once that is entered into the record on notice, then that provides us the ability to track the individual. We gather their health information that they may have had from the outside. They are assigned to a mental health staff member as well. So they undergo that mental health intake as well. That's also entered into notice there on official forms for NDOC. We also make sure that we continue any medication that they were previously taking to ensure their health, welfare, and stability.
Thank you. And can someone just elaborate a little bit on housing and how transgender and non-binary folks are housed in the Department of Corrections right now?
Dr. Williams, for the record. Yes, those decisions are determined on a case-by-case basis. We have to take into consideration the potential for being a victim for that individual, as well as the potential for being a predator for that individual, and make a decision to put them in a housing scenario that is mutually beneficial for both that individual as well as the surrounding population. So it is not an absolute, they're always going to go here or there. It is a case-by-case decision.
Go ahead, please, in Carson City.
Thank you, Chair Scheibel. For the record, my name is Don Southworth, Southworth. I'm the Chief of the Offender Management Division for the Department of Corrections. And to elaborate a little bit more on what Dr. Williams was saying, is he's absolutely correct. Housing decisions are made on an individual basis for every offender. We look at a variety of things, including their programming needs, their medical restrictions, mental health needs, along with their likelihood to be a potential victim or a potential aggressor based off of a PREA assessment. We look at their custody level, which is based on things like their disciplinary history, the severity of their crime, or the length of their sentence. But certainly an offender's status as LGBTI+ can be weighed into decisions on their housing. But what we don't want to do is develop one specific area for these offenders, because that could be a potential issue or a discrimination problem for the department.
Thank you. I appreciate that. And I think the purpose of SB 153 was never to create a designated housing unit for transgender and non-binary and intersex individuals. It was to do just what you said, to create an individualized process for assessing people as they come into the Department of Corrections to ensure that they're being housed in a place that is both safe and appropriate for them. Can you just clarify a little bit when you said that you do a PREA-based assessment? Is that for every offender or just the ones who are identified as like some kind of special population?
Yes, Don Southworth again for the record. Every offender with the Department of Corrections gets a PREA assessment upon intake, and then again regularly on a cycle. Offenders who are identified as transgender or intersex get that done every 6 months to follow up.
Okay, thank you. And is that 6-month timeline part of AR 494? I'm looking at it too, and I don't see it, but that doesn't mean it's not there.
Don Southworth for the record, there is a separate administrative regulation that covers the classification screening tools for PREA, but it's not in 494 as far as I'm aware.
Okay, I appreciate that.
And Dr. Williams, for the record, Medical Directive 316 also accounts for that assessment on 6-month intervals.
Got it. Thank you. Unless there are other questions from other members of the committee, I don't see any. So we very much appreciate you being here. We appreciate.
Chair Scheibel.
Oh, I'm sorry. Please. Yes, go ahead, Senator Krasner.
Thank you, Chair. I appreciate it. Thank you for your excellent presentation. I know that there's members of the community also watching this. So just to give a tiny bit of background before my question, what we're talking about here is based on the Prison Rape Elimination Act, which is federal law from 2003 that passed unanimously in Congress and was signed into law by President George Bush. And this was intended to eliminate prison rape. So I'm really glad to see that we're now implementing this here in Nevada. And my question is, somebody said to me, it's so easy for a man who's just wanting to sneak into the women's prison and rape the women. Is there any credence to that? I mean, it sounds like there's not from what you're saying, but just for the record, if you could please answer that. Thank you.
For the record, Terry Witherell. There is a actual committee when there is a housing accommodation request from an offender, and on the committee takes all into consideration mental health, and all of the other aspects of the offender before any decision is made, and it is made on a case-by-case basis.
And then you said there's continual assessments. It's not just the one assessment, correct?
For the record, Terry Witherell, yes, that is correct. It is a continual assessment.
Thank you very much for the work you all do.
Agreed. Thank you so much. And I think that brings us to the conclusion of Section A of agenda item number 5, and we're ready to move on to Section B.
Thank you, Chair Scheibel,
Please proceed
Vice
when
Chair
you're ready.
Miller, and members of the committee. My name is Don Southworth, and I am the Chief of the Offender Management Division for the Department of Corrections. And I'm going to briefly present on SB 307, which was passed during the regular session in 2023, as it relates to solitary confinement. An overview of that legislation. It was passed, like I said, in 2023, and all sections became effective January 1 of 2024. It defines what solitary confinement is, and I'll get into that in the next slide. But it also adopted regulations governing the use of solitary confinement, how it should be used as a last resort, used in the least restrictive manner, and for the shortest period of time safely possible. The bill requires a multidisciplinary team review for solitary confinement use. This involves not just classification, but medical and mental health staff as well. It developed and implemented certain training for staff who work in solitary confinement units and requires the Department of Corrections to present an annual report relating to the use of solitary confinement. Back to that definition of solitary confinement, this weighs heavily on a United Nations bill on the Mandela rules, but it states that housing an offender in a location where the offender is restricted to a cell for at least 22 hours per day for the purpose of separating the offender from the general population for the protection of the health or safety of the offender from other offenders, or the protection of the life or property of the staff or other offenders, or security or orderly operation of the facility or institution. And what I will interject here, and probably a couple times during this presentation, is that it is the goal of the Department of Corrections to completely eliminate the use of solitary confinement within our department. This graph here shows the daily solitary confinement counts for the calendar year 2025.
It does show during that calendar year an increase in daily solitary confinement use, but I wanted to back out a little bit and go to this next graph here, which goes from the effective date of SB 307 to just a couple of weeks ago, where we see a decrease of over 200 offenders in solitary confinement. That big spike that you see in the middle there, that relates to the swap of offenders between Ely State Prison and High Desert State Prison, where those facilities remain locked down during that transition. Next, I'll go into some of the requirements from that annual report relates to demographics of the offenders that are placed into solitary confinement. We break it down by race and age here, and what we're looking for is how this relates to the demographics of our overall population to see if there's any trends of certain groups of offenders being placed into solitary confinement over others. And we're not finding that case here. Continued demographics, this looks at sexual orientation and identity of offenders placed in solitary confinement, and we're showing that we're not putting those offenders in solitary confinement at any higher of a rate than other offenders. Here's an overview of the different reasons that offenders might be placed into solitary confinement. The first few on this list are really placed there by DOC staff. It includes Inspector General placement, institutional placement, which is there's something happened, there's a safety concern there. Medical isolation or quarantine, it's very not commonly used, but typically for highly contagious medical situations going on. Pending disciplinaries or pending transfer are the end of the placement reasons, which are really institutional placement. But more commonly, why an offender would be placed into solitary confinement are the remaining reasons, which includes refusal to move from solitary confinement. We do have a very large population of offenders that want to remain in solitary confinement and will refuse any other type of placement. Or offenders who are requesting protection or fear of safety. These are offenders that are scared. There may be some intelligence that there is a risk to their safety, so they voluntarily go into solitary confinement. Separatee, which is like an enemy or a security threat group concern. These are when, say, rival gangs, tensions heat up, we may put offenders there due to safety concerns. Or threat to their safety. This is a validated threat to the offender's safety. They get put in solitary confinement until a better, safe location can be housed. But what I want to highlight over there on the right of this slide is that over 70% of the offenders in solitary confinement are there for offender safety issues, not for any kind of punitive or department placement due to their behaviors. Some of the policies that we've implemented as a result of this, we have passed Administrative Regulation 513 relating to solitary confinement and updated AR 507 relating to restrictive housing. Both of those administrative regulations went through the Board of Prison Commissioners and became effective March 14th of 2024. I also think it's important to highlight the development of the medication for opioid use program, which is attempting to put a dent in some of the issues relating to drug use, drug debts, and the subsequent problems that are resulting from the increase in substance use problems in the department to try and address that rather than put offenders in solitary confinement. And lastly, we do still have some operational impacts and ongoing challenges that prevent us from being able to completely end the use of solitary confinement right now. Staffing is a big one. We still have ongoing staffing issues, especially at our rural locations. And their recent staffing study did recommend additional staffing for locations like High Desert State Prison. The bill required qualified mental health clinicians and defined what that was as licensed mental health clinicians, which is different than the standards for the positions that we have. So that has been a challenge for us. However, as we are trying to eliminate the use of solitary confinement, we have not submitted a request to change or add additional positions to us. Physical plant restrictions. We want to get these offenders out of solitary confinement, but we have to do it safely. Sometimes that involves adding additional fence lines, updating recreational enclosures and things like that. So we are utilizing capital improvement projects to address some of those issues. And then the As I mentioned earlier, the increased substance use issues at facilities, this has been going up pretty significantly the last few years with the introduction of things like K2 and spice. And so with that, I'd like to open it up to any questions or concerns.
All right. Are there questions from members of the committee? We'll start with Assemblymember Gonzalez.
Thank you so much. And thank you so much for the update and presentation. So during your presentation, you stated that it was a goal to end the use of solitary confinement. Do you have like a timeline of when you foresee ending the use of solitary confinement?
Thank you for the question. This is Don Southworth for the record. I don't know if I could put a specific date on the end of it, but I would say definitely within the next 5 years. The capital improvement project funding typically lasts 4 years, and that's going to go a long way in helping us get much of these offenders out of solitary confinement and get them that time out of cell that they need.
Thank you. And then my next question, Chair, if that's all right, I was curious about the offender demographics. So in your presentation, you stated that you had these demographics to make sure that certain populations weren't being overrepresented in this population. But my question is, do you have the overall incarcerated race data broken down to compare to this? Because, I mean, African-American Black folks stick out to me right away at 44%, almost 45% of the entire population. How is that not a disparity to your department in who is being put in solitary confinement?
Thank you for the question. I could certainly provide the overall demographics for our department. Off of the top of my head, I want to say that the Black or African American demographics within our department are approaching 40%. That is even higher for Clark County than it is for the rural counties. But I can certainly provide that to the committee.
Thank you. But my question was, how is this not a disparity to this specific demographic when we're looking at them being the most being put in this unit?
Don Southworth for the record. I understand the percentage of Black or African American people who are sent to the Department of Corrections is significantly higher than the population of Black and African American offenders or people in the community. That is not a Department of Corrections issue. That's just we receive the offenders that are sentenced to come to prison. And so what we're looking at here in the solitary confinement demographics is, do these demographics of offenders placed in solitary confinement correlate with the demographics of all of the offenders sent to the Department of Corrections? I think that may address your question, but let me know if you need anything further.
Thank you so much. Thank you, Chair.
Other questions? Vice Chair Miller.
Thank you so much. And to follow off of my colleague's question, the real question is because in your presentation, you literally said there was no disparity. And as we're looking at the numbers for Black and African American, it's literally almost twice as much as the next two groups of white or Hispanic Latino. So I think that's really the question, because the way it appeared to us is that with a statement like that, that it was saying that there was no disparity when we're looking at the numbers. And so again, and we do already know what the largest group of incarcerated is. So I'm going to pivot and ask this question. We're talking about attempting to limit, reduce, and eliminate solitary confinement. But the question is, especially while looking at these numbers, is do you have information on what gets someone into solitary confinement, especially for our Black and African American individuals that are incarcerated? What's causing the solitary confinement, especially compared to other groups?
Don Southworth for the record. Thank you for that question, and I want to provide a little bit of clarification. When I'm talking about the no disparity between the different demographics, it's in comparison to our overall offender population. So yes, there is a very significantly higher percentage of offenders, of the overall percentage of offenders in solitary confinement that are Black or African American. How that relates to our total population as a department is what I'm referring to there. But as far as the placement reasons, there was a slide that talked about the different placement reasons, and I could break that down further, the different placement reasons by the demographics as well. I don't have that here in front of me, but like I mentioned during the presentation, the greatest reason offenders are placed into solitary confinement, over 70%, is due to safety concerns and not punitive placement by staff.
And thank you for that. That would be so helpful if you could send us that information of, again, with these placements, but how it is broken down by race. And if you could submit that to the entire committee, please. Thank you so much.
Other questions?
Chair Scheibel.
Yes, Senator Krasner.
Thank you, Chair. Thank you, sir, for your presentation. I did have a question. You mentioned the United Nations Nelson Mandela rules, and then you just mentioned it again regarding the personal safety of the inmate. So let's say there's an inmate that's being targeted for whatever reason. They're young and they're being raped, or they're for some other reason. And they want to be in solitary confinement for their safety so they don't get killed or raped. What can we do now, or what can you do now as we change this? How will they be safe? Thank you.
Don Southworth, for the record. That is a great question, and that is an issue that we deal with on a daily basis. Is we have quite a few offenders that refuse to leave solitary confinement because that is where they feel the safest. And so we have a variety of different options we could look at, including speaking to the offender, having mental health staff talk to the offender about any issues that they may have, providing them any kind of mental health treatment to address paranoia, or sometimes it is a legitimate threat to their safety. If that's the case, communicating with them the different types of units that we have. For example, Lovelock Correctional Center is a majority sex offender yard. So a lot of times offenders will go to solitary confinement as a sex offender because they're scared of general population. But communicating with them that, hey, this particular facility, a majority of the population there are sex offenders, that may alleviate some of their concerns and they may agree to come out there. Ultimately, there are some situations where the offender continues to refuse to leave. So we want to do what we can in order to get them that out of cell time. It may be very small groups, which is where some of these physical plant, additional fencing, recreational enclosures can get them at least out of their cell for over 2 hours a day. As kind of a last resort, we could also review these offenders for interstate compact transfers. We have contracts with many states around the country where if an offender has legitimate safety concerns within the Nevada Department of Corrections and we really can't feel comfortable getting them out of solitary confinement anywhere within our department, we can contract with another state and send the offender there. It typically works as a swap where we send one of our offenders there and they send one of their offenders back to us in return.
Thank you. Thank you, Chair.
All right. Any other questions from members of the committee? Not seeing any. We thank you so much for being here and for your presentation. I think that brings us to the end of agenda item number 5, and we'll move on to agenda item number 6, a conversation on timelines from release from custody after bail has been posted. We'll go in order of the agenda. We'll start with the Las Vegas Metropolitan Police Department.
Good morning, Chair and members of the committee. My name is Joshua Martinez. I'm a captain with the Las Vegas Metropolitan Police Department. I'm going to have our Deputy Chief in charge of the Clark County Detention Center present today. Deputy Chief Page will present.
Good morning, Chair and members of the Interim Judiciary Committee. I am Deputy Chief Cherie Page, overseeing the Detention Services Division. I want to thank you for giving the Las Vegas Metropolitan Police Department this opportunity to discuss our policies and procedures at the Clark County Detention Center regarding bail and releasing of inmates. So releases are received by the courts, can come with conditions imposed by the courts, such as release to a program, treatment facility, electronic monitoring program, administrative OR, bails, bonds, DA denials, and no charges filed. When it comes to accepting bail payments, the detention center does not accept payment, but we are notified through the courts or pretrial services that is an extension of the courts of the payment received, and that bail receipt is sent to us through email. Many of the courts send these and so releases when inmates are going to court, those transactions when they are in court are sent to us through custody status slips. Those are emailed to the jail and received. And once those are received, they are verified in Odyssey by contact. They are verified in Odyssey, and if there's any discrepancies, we contact the courts to work through the discrepancies. Those custody status slips are received and processed in the time order that they were received from the courts. This demonstrates that the release of inmates is not solely a jail task, but rather a collaborative process that requires coordination and support from multiple stakeholders and criminal justice partners. So before getting into the steps that must occur when we are in the process of releasing inmates, I want to provide you with a number of the number of inmates booked and released over a 12-month period. Please note that these numbers reflect releases from May of 2025 to May of 2026. So the Clark County Detention Center booked in 51,694 inmates, which is an average of 4,307 inmates per month and approximately 141 inmates per day. We actually released 51,385 inmates, which is an average of 4,282 inmates per month, or totals like 140 inmates per day. Our field services section transports on average over 350 to 500 inmates to court Monday through Thursday. That does include initial appearances, and approximately 60 to 80 inmates to courts on Fridays. And then on the weekends, Saturday and Sunday, which is strictly initial appearances, we transport at least 50 to 80 inmates. So these numbers show how many individuals are moving in and out of CCDC 24 hours a day, 7 days a week. To make sure that we are releasing the right individuals, it is important that we verify the processes and steps that are followed for each inmate release. Our records section has created a release verification document that is used for each inmate file that is being worked up to get those inmates released. That checklist is in process to eliminate erroneous releases from occurring. And I'm going to provide you with a few important steps the lead releasers must complete when preparing the file for inmate releases. So it is imperative that they verify the inmate's ID, name, and charges, that all charges and cases are released for that particular inmate. We also look for if the inmate has any other open cases within Clark County, and for cases that they are not in custody on. Sometimes we have inmates that will go to court for cases that they aren't in custody, and we have to hold that file so we can wait to see what the court's disposition will be pending that particular case, if they should be remanded or if that case is going to be released. We have inmates that are ran through the system to see if they have any outstanding warrants that popped up while they were in the jail at that time during that lodging. And all of the systems are checked for any AKAs and aliases to determine if that inmate has any warrants for any other names that they could have been booked in prior to. The violent charges and the felony DUIs, those files have to be reviewed by our supervisor in the record section prior to that release. And the less that is working up the file for release and the less that is going to release the inmates from back into the community have to be two different people so that we can make sure that we're doing our checks and balances with that process. And all of these steps are completed for the release of the inmate. Then when all of these steps are completed, the corrections officers and the detention services technicians are then contacted to prepare the inmate to come down, be placed in our transfer release area. They are given back their clothes that they came in with so that they can change. And then their property and their money is worked up to be released and given to them as they're being released back into the community. So these steps are followed and other factors must be considered when we're doing this release process. So your DUI drugs and your domestic violence arrests have a minimum of a 12-hour hold per our Nevada revised statutes. We are notified when we receive a cash bail immediately. However, if that bail is coming from a bondsman, they have their own procedures, so that can greatly delay the time between when we receive the payment is received and when the detention center is being notified. Besides inmates that are being released back into the community, CCDC also releases many of our population to other detention facilities, treatment centers, and other law enforcement agencies. These releases are scheduled and would take priority over inmates that are released back into the community. Due to the high liability and around releases and staffing constraints and the physical layout of our releasing area, we only do one type of releasing at a time. So that means if we have Nevada State Prison, Nevada Department of Corrections coming in to pick up inmates that are being released to prison, we halt any other releases, and those releases are done at that time. Some examples of the agencies that we release to, of course, are our local jurisdiction, City of Las Vegas, North Las Vegas, Henderson, Juvenile Detention Centers, Steins, Lake Crossings, Ross and Neal Psychiatric Hospital, the Marshals, ICE, other jurisdictions that are coming for fugitive inmates that have fugitive holds, Freedom House, West Care, Vegas Stronger, Options, Scram, and other treatment agencies. So lastly, to wrap up, with conjunction to those releases, any releases that we have that pertain to our 287G Warrant Services Officer Program, when an inmate is booked on a felony or a Laken-Riley Act charge and is born foreign, we do notify ICE. ICE may choose to notify us, and if they do and they are interested, the person, they will send us either an I-200 or I-205 form, which the I-205 form is that a guarantee that that they are going to pick up the individual, and the I-200 form is notification that they will possibly be picking up the individual. Either way, our warrant officer gives that form to the individual. They're responsible for notifying and giving that form to the individuals or serving the warrant to the inmate. We then, if the inmate signs that, no. So we serve the form, and then the inmate is held up to 48 hours past their release from custody to give ICE that opportunity to come get them. If ICE chooses not to act upon the warrant and come get them, then they are either released back into the community or released to a program or pending EMP or whatever that release for the charges states. And for inmates that are released to other detention facilities or NSP, if ICE doesn't pick them up, then they would continue on with those releases. And that's all I have.
All right, I think we have some questions here. I'll start with Vice Chair Miller.
Thank you so much, Chair. And I would like to say on behalf of the first female majority legislature in the United States, congratulations on your historic promotion, and it's great to see you here. With that, my question is, and I appreciate a detailed presentation of, I think for me, some questions were already answered, actually questions I didn't have, but it was just more information on the different categories of releases. For me, where this concern came from is I've had a number of constituents, or more so, I should say, tourists even as well, get in this situation where the gap in time between the moment that bail is paid and the individual is actually released. And so I think we all in our mind envision a system where, okay, we paid bail and now we're just going to wait and here comes my person in 15, 20 minutes, right? But we've heard instances of 10, 12 hours and so on. I've also heard from employees where they say that oftentimes people may be released. It could be in the middle of the night, 1, 2 in the morning. And at that point, there's no infrastructure or resources to help support this individual if they're released out on their own. So could you respond to those two scenarios? And because really it's about both of those are concerning and what we can do to improve that.
Cherie Page for the record. And thank you for the kind words. It is our intentions to get inmates released as quickly as possible. However, we do have to follow a stringent checklist to ensure that we are making sure that we have checks and balances, that everything matches up. Because we receive releases for bail as well as from court, those releases come in and they're in timestamp order. So based upon that timestamp order from a 24-hour rolling time period, they're worked up to be released. Each release is taken through the same checklist regardless of the charges or how it is received. So for those, like you have individuals that come in from out of state, they still go through that same checklist, and provided that they only have that one charge and everything lines up, we get them out of custody as quickly as we can. We don't distinguish between bail being posted and court slips coming from the courts, because when they're all received, we just put them in timestamp order to get them released. Other things that kind of play a part in us releasing inmates is we do a formal count in our facility twice a day. So during that count time, we do not release any inmates. We also do a change of shift twice a day. So within that time frame, probably I would say maybe 2 hours, we do not release any inmates in that time frame. So yes, we do release 24 hours a day. That could mean that they are released in the middle of the night. However, when these individuals communicate that they're from out of town or that they don't have a means to contact someone, we make sure that they get in contact with someone so that they can get to where they need to go without being just stranded and walking around in the downtown area. So all attempts are made to get our releases processed in a efficient time frame while covering our strict guidelines and policy and procedures that we have set forth to ensure that we're not making, everything is matching with the case numbers and the information, make sure that those individuals aren't wanted anywhere else, and as well as making sure that that inmate file is complete in its totality without any errors.
Follow up, Chair? Thank you for that. With that, do you have information on what is, on average, what someone could expect? I appreciate that the processes that we must go through, but what on average can someone expect from that time that release has been ordered to when that individual is actually walking out? And also, has the department considered or reviewed best practices from other counties around the country with the same size population? Because I know there's a lot of different styles that are taken, some release at the same time every single morning, so everyone knows they can double up, that coverage of the shift change. Just if you could respond to both of those as well.
Cherie Page for the record. We typically tell inmates that it would take anywhere between 6 to 12 hours to be released. We like to get them done within, as less time as possible, but we do tell them a time frame of 6 to 12 hours. Taking into considerations the things that I told you to include if there's a outage with the systems or one of the systems is down. I'm sorry, excuse me. And we are continuously looking at other processes to see what we can do within the jail to minimize, like, for instance, the amount of paper that we're currently using, to try to look at more digital formats that would potentially make our processes a little quicker, even though we still would have the checks and balances. But that is a continuous thing with looking at other agencies and seeing how they are doing the processes for releases and the newer technology that is being used.
Thank you so much. Thank you, Chair.
Other questions? I have a quick question. At this point in time, would you say that you do have enough ankle monitors or other monitors to accommodate all of the court orders for OR releases with monitoring?
Unfortunately, at this time, I don't have an answer for that question. I can get with my house arrest lieutenant and find out and make sure. I haven't particularly heard anything since I've been in this position, but it is something that I can look into and follow back up with you.
Thank you. I would appreciate that. I know that has happened historically, but I also have not heard about that in recent months. So I'm hoping that either we've caught up with the number of ankle monitors or we're releasing more people without monitoring. Yes. What I'm concerned about is that we're keeping more people just in custody without releasing them and we're matching the releases to the number of monitors instead of matching the number of monitors to the number of releases. So if you could follow up, that would be very much appreciated.
I will definitely do that.
Thank you. All right, not seeing any other questions from our members on the committee. We will invite up the Washoe County Sheriff's Office to tell us about what's happening in Washoe.
Chair Scheibel, Vice Chair Miller. My name is Adam Miller. I'm the Director of Government Affairs for the Washoe County Sheriff's Office. With me today is Assistant Division Manager for Detention Over Operations, Colin Dowling. I guess I'll start by saying our colleagues down in Metro did a very good job of explaining kind of the challenges they face in their process. So with that, I don't think we need to belabor our process as it is almost identical to theirs. Given some of the differences is just kind of our timelines for bail release. We state that it should take up to 8 hours. Obviously, that is barring any unforeseen circumstances or complicated cases. And we annotate on our website that time served does occur at 5 a.m. daily. So with that, I will just kind of pause and we can run with questions.
Okay, members, any questions? Then I would just briefly ask, because I know that is a model that other counties around, that I was aware that Washoe does and other counties around the country do as well. Can you speak to the effectiveness of having a same standard time release every day, if you believe there's an effectiveness to that?
Colin Dowling for the record. The expectation of running the facility in a standardized fashion allows us to communicate to the public. For instance, we were just looking at our website on bail. We communicate out to family through the website that are interested in bailing out their family member that they should expect, if the person is getting a time served release, if they wait in custody until their time served, they'll be released at roughly 5 a.m. the next day. That can help coordinate getting rides available. It allows us to, as our counterpart in Las Vegas mentioned, we have multiple counts a day so that we know if we have a release party that we can do before we finish our 5:30, 6 a.m. count, then it gives us a higher likelihood that we're going to have an accurate count, keeping our facility safe. It's also when we have the consistency of our shift changes, of our meal services, of court appearances, we run video arraignments, for instance, out of our detention facility, and they happen in the same time window every day. So we know that we're going to have paperwork returning from the court at a certain time, and we know roughly what our processing time is, so we can anticipate coordinating with between our civilian staff that's processing the releases and our commission staff that's effectuating the releases. We can have better coordination of effort there.
Okay, thank you so much for that response. Not seeing any additional questions. Thank you for your presentation, and I will go ahead and close this agenda item. Next on the agenda, we have a presentation from our public defenders, beginning with our public defenders from Clark County. And are you doing the presentation in conjunction with Washoe? Okay, so the presentation will be both from our public defenders in both Clark and Washoe, and I'll give you a few moments to get settled, and then whenever you're ready, please proceed. Yeah. This is the judicial. This is the first one we had this morning, if we could. She's gone.
Good morning, Vice Chair Miller, members of the Interim Judiciary Committee, Paloma Guerrero with the Clark County Public Defender's Office, and I will let my friends in the north introduce themselves.
Thank you. Marcy Reba from the Washoe County Public Defender's Office.
And Marissa Crook, also from the Washoe County Public Defender's Office, Marissa, last Crook.
And our main desire for this presentation is to see people released quicker, and this presentation is to provide ideas to help reduce harm of midnight releases until that vision is realized. And our main concern is what Vice Chair Miller explained earlier, is these releases that happen during the night between 10 p.m. and 6 a.m. when transportation, family support, shelters, and treatment services are unavailable to people. And to exemplify why this is a problem, we had a client, well, we have clients with all sorts of needs and services that they should get when they're released. And we had a client with an intellectual disability, we'll call him David, and David can't function in the world like we can, he needs support. So what our office did is we had housing and programming coordinated for his release at 8 a.m. for the next day when he was set to be released. But what ended up happening is that he was released at 1 a.m. So then we had to scramble, we got him a hotel room, we were in contact with his mom until the morning until he could get those services. This article is something that we found about the perils of late night releases. And the main point in this article is how these midnight releases can set people up for failure and also place them in immediate danger. And I'll hand it off to Marissa Crook in the north.
We thank you, Chair Scheibel, Vice Chair Miller, and committee for allowing us to present on this, inviting us to the table. One aspect that we can bring to the table to complement what Metro and Washoe Sheriff articulated is a possible proposal for clients who want to be kept and held until the morning. We were discussing a possible solution with the Washoe County Sheriff's Office, and it sounds like potentially having a waiver where a person can choose to be released in the morning instead of whenever they could be released as early as possible at night could potentially alleviate these concerns. As you heard from Metro and Washoe, currently they can release people 24/7 to avoid liability. They release someone as soon as they are able. But obviously, it can be harmful and dangerous for an individual to be wandering on a road, especially up here in Washoe where PAR is north outside the part of the metropolitan busy area. It can be an isolated road at night. A lot of clients from the Public Defender's Office don't have a cell phone or family who can transport them. California looked at a similar proposal that would allow people to voluntarily choose to delay their own release. And that California bill was based off of a woman who was released late at night, didn't have transportation, and was hit by a car on a street that wasn't well lit near a detention facility. So the voluntary delayed release that other states have implemented, I believe that article that Paloma mentioned went over 10 other jurisdictions that have implemented a voluntary release program, and it can improve safety. Granted, there's going to be individuals who want to be released in the middle of the night and don't want to postpone it, but many individuals are aware of their lack of resources and their mental health concerns and would choose to delay their release. Currently, the Washoe County Jail, it's our understanding that if there's severe safety or mental health issues, they can release, but sometimes a person can be in a gray area where maybe the jail, for liability purposes, doesn't feel like they can force a person to stay, but where a person may choose to do so. I had a client who I refer to as John for the purposes of this story, who was sentenced to diversion to attend mental health court. He had family support in the area, but they were not expecting him to be released for another week. There was an error in court paperwork, and he ended up being released in the early morning when his family wasn't expecting him to. He didn't have an operable cell phone, and his parents were sleeping and not awake. And so he was wandering the streets in northern Reno and had a really difficult, challenging morning that could have triggered a relapse and undermined the work that the Washoe County Sheriff's Office had done to stabilize him with medication since his arrest. He's an individual who absolutely would have chosen a voluntary delayed release because he had been stabilized enough to recognize that he didn't have the resources to be able to navigate the streets in the early morning. Next, I just want to overview. The Washoe County Sheriff's Office provided us with an overview of the resources that they currently have for individuals who are released. There is, for individuals who are released in the early morning, RTC Flex Ride, which is to accommodate an issue that we have with the local transportation. So if you visit the facility up on Parr Boulevard, you'll see a bus station right outside the premises, which you may think is amazing and allows people access to public transportation. But after construction about 2 years ago, the Regional Transportation Commission suspended service to that stop and has not reinstated it. And so if someone, even if someone can afford a bus pass, or say they can't and the jail provides them with a bus pass, they need to get to the Bonanza Casino, which requires them walking all the way over to Virginia Street. And so the RTC Flex Ride is something that people can utilize. A study on the Washoe County's website, they say in April of 2025, there were 27 people who were released before 5 a.m. And then of those who were released after 5 a.m., when they could take advantage of that RTC Flex Ride, about 44 took advantage of that shuttle to take them to the Bonanza Casino on Virginia, where they can then utilize the bus system. We also reached out to attorneys in the rural areas to try to understand what it looks like there. And the picture in the rurals is much bleaker than it is in the urban areas. When Marcy served as the director for the Department of Indigent Defense, she learned that in Lyon County, if someone is arrested in Dayton and then taken to be detained in Yerington, they're released in Yerington with no way to get to Dayton. In other rural areas, for example, in Eureka, people, it looks like, are not being held in Eureka, they're being held in Ely or another facility. And if a person isn't able to get back to a Eureka where they were when they were arrested, deputies will often pick them up from the facility and take them back to Eureka. There are additional issues relating to bonds, which I know is slightly off topic, but the attorneys in the rurals wanted us to, or just thought it was relevant to mention that in Ely, there's currently no bondsman, and so families have to coordinate and travel to Elko to try to release someone. And just while we're discussing bonds issues, in Washoe County, the Public Defender's Office has observed that judges here, instead of either setting a cash bond or release with protective conditions, a lot of judges here are doing cash bond with release conditions in a majority of the cases, which increases the amount of time that it takes for a person to be released if they post bond. And for example, if a part of their cash bond is a GPS monitor and the court requires the GPS monitor to be installed prior to release, the GPS has to be installed at the jail. People from Intercept have to travel, and people who are incarcerated have to pay an extra fee for that transportation for Intercept up to the jail. But also in Reno, we have, even in Washoe County, even though we're not a rural county, we have clients who are arrested in Incline and are released from the Washoe County Jail and may not have a way to get to Incline, which is not serviced easily by the bus system. We also just wanted to note, and this is something my understanding is the Washoe County Jail does as much as they can with the resources they have, and so this could be an additional resource issue, potentially additional resources needed for the detention facilities, but transportation to individuals to treatment facilities. Currently, if a person is court ordered to be transported directly to treatment, the Washoe County Jail has a service that will transport the person directly from the jail to the treatment facility. I believe the Veterans Unit additionally will provide treatment for veterans to treatment facilities, even if it's not court ordered. But for individuals who it's not a part of their release conditions, but who may want treatment, additional resources or funding could also help just some of the safety concerns and setting people up for failure related to release. We see clients who are, homeless, don't have family or friends in the area who can transport them to treatment, who maybe are given bus passes by the jail. Let's say they take the RTC Flex ride to the Bonanza Casino and they have 2 bus passes. One bus pass they can take down to the downtown hub, which is on 4th Street, and from there can get transported, can take a bus to the treatment facility. But one thing that we see is that sets clients up for failure because that 4th Street bus station hub has a lot of individuals who are engaged in drug use. And so a person is likely to run into people who they've used with before on their way to treatment, whereas additional resources, which would allow the facilities to transport individuals who would voluntarily request to be transported to a treatment facility, could help set them up for more success, especially if a person is wanting treatment. Sometimes we even see this happen if we even have a bed reserved for someone. Just the struggle of getting from jail to the treatment. If you don't have family to drive you directly, you can come into contact with those people in your life who can set you up for failure. Let me just look at my notes. And with that, I'll turn it back over to Las Vegas to talk about some additional issues with behavioral health.
Paloma Guerrero for the record. So these midnight releases make it so that we're missing that warm handoff that people may need. During those times, social services are closed, shelters are closed, mental health services are closed, substance abuse services are closed. And given that there's this gap, our proposal is for this completely voluntary request that people may give to be held until those services are available. So until the morning time. And the goal here is just to prevent release into that service vacuum. And I'll hand it over to Marcy.
Thank you, Marcy Reba, for the record. Another challenge, as if we haven't presented enough, are many individuals that are leaving custody are part of that 1% club where you don't have any sort of charge on your phone when you're taken into custody and it ends up dying while you're waiting to be released. We had that opportunity to talk to the Washoe County Sheriff's Office, and we did learn that historically they had a direct line to a cab company in their lobby, but that phone was removed when they updated to internet phone. So at this point, there is no phone for public use at the Sheriff's Office. There's no chargers that could be used, and the only way if you want to get a hold of a family member is to walk across the street to the gas station that's across the street to see if you can use their phone, or possibly, as we've talked about, to either walk to the Bonanza or take the eFlex ride system to the Bonanza. As we've started discussing, do you want to do the next page, please? Our proposal number 1 is the safe hours release. Again, this would allow eligible individuals to be released between 10 p.m. and 6 a.m. to voluntarily remain in custody until 6 a.m. by signing some sort of written waiver. So this would be a discussion with that individual of whether they feel that it'd be safer if they stay in custody until a 6 a.m. release, or if they wanted to be released immediately. For inspiration, we could refer this committee to the Washington DC Code 24-211.02a, and this requires that a facility must allow individuals to remain until 7 a.m. for safe release if requested by that individual. So we'd refer this committee to that. When we're having our discussions with law enforcement, another one of their concerns is some sort of liability protection for the facilities. We learned they want to restore these individuals to freedom on the timeline that's been directed. So there is concern that if they voluntarily hold these individuals, do they face any sort of liability? So we'd ask that any sort of bill draft include a protection for law enforcement. We also want to make sure that law enforcement has that opportunity to hold individuals with mental health, special needs, or the elderly, if deemed for their safety, or to allow them to meet with mental health staff. We've heard stories of individuals with mental health issues being released too quickly and not being able to connect with our mental health providers. Our third proposal would be the safe transit package. As you can see, we're requesting access to charged phone, transportation assistance, family contact, shelter information, and treatment referrals. We, again, are asking you to look to DC, where they require apparel to be provided to individuals. And again, we've had that opportunity to talk with the Sheriff's Office today. And they do say that they are lucky in Washoe County that they have donated clothing, where people are arrested maybe in the summer and they're released in the winter. The law enforcement staff make sure that they have sufficient clothing if they're being released, but this may not be available in our rural communities that don't have the same level of resources that we have in Washoe and Clark. So we're asking that you add some sort of requirement to ensure that sufficient apparel is there if they're being released. Medication, again, we've been able to talk with the Sheriff's Office. It's our understanding that they're either provided with a prescription or they're provided with approximately 7 days of a prescription medication. The concern that we have as public defenders is in Washoe County, it takes 30 days to set up any sort of connection with a treatment provider. So there is that concern. But again, with this being said, there's been an open conversation for us to reach out to NavCare in Washoe County to try and address this. The transit, as we've heard about the bus stop, that's paid for by the Sheriff's Office if the individual doesn't have sufficient funding to be able to pay for that themselves. But we're unaware if the rural communities are able to provide something, because in reality, there just isn't the same level of public transportation in our rural communities that we see in our metro areas. So that is some concern that we have of whether there could be any sort of transportation provided by law enforcement, like we heard in Eureka, where they actually drive the individual back to the county. Housing, if they could verify housing or shelter. And we just want to make sure that they have that basic discharge kit. So if you're being released, that they have that ability to ensure that they're being released safely. And we just wanted to point out that this is a collaborative reform, and we wanted to say thank you to this committee for starting this conversation. And we wanted to say thank you for Sheriff Balaam as well as his staff that's been open in talking with, can we make policy changes now rather than having to wait for any sort of bill draft request. So we are going to continue this conversation. We look forward to working with Clark County, but this is something that the judiciary feels needs to be addressed, defense attorneys and staff in these correctional facilities. So we would like to let this committee know that we are addressing this in a collaborative way, and we do thank you for adding this. And we would turn it back to Clark County.
Paloma Guerrero for the record. So as a recap, we have the safe hours release statute. We have the liability shield to protect our law enforcement in jails, a behavioral health review option, phone charging and access, transportation partnerships. And the last thing is just data collection. There is a data record gap. So we'd also ask to track releases between 10 p.m. and 6 a.m., requests for delayed release, behavioral health related releases, and also transportation assistance that was provided. And in closing, no Nevadan should face avoidable danger simply because release occurs after midnight. Safe release is smart public safety. Our goal here is just to protect the community. And we'll open up for questions.
Thank you so much. Questions from members of the committee? I don't see any questions. I have a quick question. Well, maybe a quick question. I am sure that we are not the first jurisdiction to face these issues with people being housed in one city or one location when they come from or were even arrested in another location. And I'm just wondering if you've seen maybe nationally or in some of our neighboring states, good programs that are working to help get people back to, you know, where they actually live once they're released.
Marissa Crook for the record. When we were researching policies on voluntary delayed release, we didn't see anything involving specifically addressing that issue. But as I mentioned, we did learn in speaking with rural attorneys that in Eureka, when individuals are arrested in Eureka and detained somewhere else, the deputies do give a person a ride back to Eureka. And so it would be potentially a good idea to reach out to the detention facility in Ely and the sheriff and the deputies in Eureka to better understand that process.
Thank you. I agree. And it seems like something that might be able to be replicated in other jurisdictions, because I know that White Pine County and Elko County are not the only places that have, you know, multiple population centers, if you will. And so I appreciate that. Thank you. All right. Not seeing anything further, that will wrap up agenda item number 6 for us.
Thank you.
Thank you. And just for everybody's planning purposes, it is my intention to go to lunch at noon. So you can keep that in mind as you make your own plans for the day. We will move on to agenda item number 7, the Nevada Gaming Control Board.
Very good. Good morning. Chair Scheibel and members of the committee, my name is Mike Dreitzer. I am the Chairman and Executive Director of the Nevada Gaming Control Board. Here with me today to my left is Nathan Riggle, our Chief of the Administrative Division, and Alicia Ray, to my right, the Board's Senior Policy Advisor. I first want to thank you for the opportunity to provide an update regarding the implementation efforts following passage of the gaming-related legislation adopted during Nevada's 83rd legislative session. Since conclusion of the session, the Nevada Gaming Control Board and the Nevada Gaming Commission have undertaken extensive implementation efforts across multiple divisions of the agency. These efforts involved coordination between the board, the commission, Office of the Attorney General, technical staff, and industry stakeholders to ensure the statutory changes adopted by the legislature were effectively incorporated into Nevada's regulatory framework. To date, the agency has completed numerous regulation projects involving enforcement, technology modernization, anti-money laundering compliance, wagering systems, gaming salons, pari-mutuel operations, technical standards, and administrative streamlining. The presentation today summarizes the major legislative measures approved during the session and the implementation actions completed by the agency following their passage. We'll turn then to slide 3, which is SB 46. SB 46 focused primarily on enforcement modernization, judicial authority, and suitability-related provisions. Following the passage of SB 46, the board and the commission completed amendments addressing retained jurisdiction following voluntary surrender of licenses, updates to enforcement applicability involving registrants, and related suitability and investigative provisions. The associated regulatory amendments became effective in March of 2026. Turning to slide 4, AB 58. AB 58 represented one of the agency's largest technology and modernization implementation efforts following the session. Implementation actions for this included adoption of administrative approval procedures for gaming devices and games, modernization of gaming technology approval pathways, updates involving wagering accounts and cloud computing environments, and removal of obsolete regulatory categories related to cash access and global risk management. The agency also completed multiple technical standards and technology-related amendments associated with this substantial effort. Collectively, these changes were intended to modernize Nevada's regulatory structure while also preserving the state's long-standing integrity and oversight standards. These amendments became effective January and February of this year. As part of this effort, I'll also note we had an overhaul of the technology division within the Gaming Control Board. We have new leadership there and an entirely new set of standards with which we deal with the individuals bringing products to the state of Nevada for review. The idea being that we are able to review products at the speed of business, again, without giving up any sort of standards in terms of our oversight. Slide 5 is SB 459 as it pertains to gaming salons. SB 459 addressed gaming salons and expanded operational flexibility within those specific environments. Following the passage of this bill, the Commission adopted amendments to Regulation 5.200, updating salon operational requirements, minimum wager provisions, reporting requirements, supervision standards, and public opening approval procedures. These amendments for SB 459 became effective in September of 2025. Slide 6, please. SB 203 modernized Nevada's pari-mutuel wagering framework. This long overdue implementation effort included repeal and restructure of outdated disseminator provisions, updates to service provider structures, and modernization of live broadcast reporting, oversight, and registration requirements. They became effective in January of 2026 this year. Slide 7, SB 256, pertains to the expanded disgorgement-related authority concerning unlawful gaming activity. Implementation of this legislation primarily occurs through judicial application and enforcement mechanisms, with the statutory provisions became effective October 1st, 2025. Slide 8 will note that in addition to the direct implementation work associated with the session bills I've just described, the board and commission also implemented numerous related modernization initiatives across the agency. In total, inclusive of the session bills and changes in the non-session related bills. There were a total of 43 regulatory projects done within the last year. General categories of technology modernization, updates to regulations governing cloud computing, wagering account functionality, cyber security reporting, gaming device approvals, associated equipment, hosting center operations and technical standards, AML, anti-money laundering regulations, which allowed us to provide updates to reporting requirements, compliance obligations, and regulatory provisions designed to support effective risk management and regulatory oversight. In addition to this, we overhauled Regulation 30, which updates the horse racing operations in Nevada, including addressing operational requirements, disciplinary procedures, licensing and integrity-related provisions, and longstanding regulatory clarifications. We had further enforcement and investigative processes updated, which involved regulations governing surveillance, exclusion-related provisions, gaming operations, and other regulatory tools to support the board's ability to effectively monitor and oversee licensed gaming activities. In terms of gaming operations, a broad range of operational areas were also addressed, including salons as mentioned, wagering-related activities, house rules, chip and tokens, disseminators as mentioned, and other operational requirements affecting day-to-day gaming activities. These efforts reflect our commitment to maintaining a strong regulatory framework that is responsive to innovation, effective in its oversight responsibilities, and capable of supporting the continued success of Nevada's gaming industry. Slide 9. In closing, the board and commission have devoted substantial effort, as you can see, towards implementation of the legislation adopted during the 83rd legislative session. To date, the board and commission have completed nearly 60 regulatory projects associated with both legislatively mandate changes and broader modernization initiatives identified during the operational review. That is our presentation. I'm happy to answer any further questions you may have.
All right, questions from members of the committee? All right, I don't see any questions. So we thank you so much for your presentation. And I think that brings us to our conclusion of agenda item number 7. Thank you for being here.
Thank you very much.
All right, we will invite forward the Cannabis Compliance Board and open up agenda item number 8.
Morning, Chair, members of the committee. Thank you for the opportunity to present today. I'm our Executive Director, Michael Miles, newly appointed Executive Director, and next to me is a newly appointed Deputy Director, Steve Gilbert. I'm going to quickly run through the agency operations. Again, our most important idea here is to protect public health and safety for consumers, medical patients, and visitors to the state. Also to maintain the industry's economic benefit to the state. We do this through 3 departments within our board. We have the admin department, which handles all things licensing and registered agent cards. We have our health and safety department, which is our audit, our inspection team, and our lab inspectors. We have our investigations team, which does suitability reviews on all potential business owners and also checks funds similar to what gaming does. And we have our law enforcement wing, which is only a few officers and they're under our investigations. And as of now, they've been handling our issues with AB 504, which I'll get into shortly. A quick industry snapshot. We have 6 different types of license: cultivation, production, independent testing labs, distribution licenses, retail dispensary, and consumption lounges. There's just under 15,000 active cannabis agent registration cards. And as you can see, licenses are spread out. By far, majority is in Clark County, and then right after that, Washoe County. Of the almost 15,000 registered cannabis agents, there's a little over 13,000 that are employees, and the rest are split up amongst various board members, executives, officers, owners, and volunteers. We threw up the taxable sales as well as the wholesale and retail taxes that have been collected over the last several years. Just remember, under the fiscal year 26, we don't have the last quarter in there. And also remember that last quarter includes 420, which is usually a big selling event. Our regulatory implementation of all the bills. We have, the CCB has one distinct problem that is being corrected at the moment. In fiscal year, under the 23 session, we were ordered to go from a gaming style regulatory process to under the APA process. This has just occurred. Last week, all of our NCCRs, which used to be our regulations, have now been converted and are up on the website for the NACs. The new process, instead of the NCCRs 1 through 15, now they're the NACs 6, 7, 8, A through D. And it literally just went up last week. Reg changes for the 23 session are being voted on by the board on Thursday. Those changes are still in the NCCR format, so the LCB will have to convert them before they go in front of the commission and then get included with the NACs. For the 25 bills, we had 3 initial workshops from November, December 2025. This were for all the bills, including SB 157, AB 76, and SB 168. We held 2 additional workshops in March of 2026, again, for further refinement of the language. And in May, we submitted all those changes to LCB. Again, problem with that is all those changes are submitted in the NCCR format, so they'll need to get updated. We're going to help them with that. We're going to make the process a little quicker and update it to the NAC format for them and then resubmit. Quick overview of AB 76. Again, this was our run the agency bill. It was a lot of minor regulatory updates that needed to happen. A couple of the important things on this were the Cannabis Advisory Commission had to handle 2 studies, one on taxation structure and one on hemp-derived intoxicating THC products. Another one of the big ones was we updated the packaging weight and THC limits. Basically, possession limits went from 1 ounce to 2.5 ounces. And that has all been updated throughout the state. Again, the study on cannabis taxation, the CAC created a 5-person subcommittee to study the cannabis taxation issues. Again, this is just the difference between our excise wholesale tax and our retail tax on cannabis products. They're just studying the issue and trying to decide how best to move forward and still keeping the same amount of tax revenue coming in. We should hear the results on that come in November of 2026. There's also a study on consumable hemp. Assemblymember Miller may know a little bit more about that than even I do, as she's been willing to help and stand in as a subcommittee member on that study. Again, this study is reviewing existing laws and ordinances governing consumable hemp products, enforcement of restrictions and gaps against the sale of illicit hemp products, the federal laws and regulations governing consumer hemp products, to recommend safeguards regarding interstate commerce and Nevada state compliance, age gating, and again, this study hopefully will be completed in October of 2026. SB 168, this process was mostly about hold orders on cannabis and cannabis products. Whenever one of our inspectors found that there was a health violation, we would instill a hold order on that product throughout the state. We use that through the metric system. So in case the cultivator sold products to multiple dispensaries, all the dispensaries would get that hold order and pull all those products off the shelf. This basically created a policy where we could implement that hold order, but within 30 days we had to have a hearing in front of the board. These regs are obviously still going through. Again, they were submitted with the rest of them in May. However, we did create a process for this. We already had one instance in November of last year where one of our cultivators used improper pesticides on some of their products. We put out the hold order. Everything was pulled off the shelves. We held the hearing within 30 days. The board ordered it to remain held until all the products were destroyed. And within a few months of that, all the products were destroyed. SB 157. This is the only bill where we had issues in the workshops and working with industry on it. And we're likely going to see a similar bill come up again this session. Again, this was an update to the independent testing lab requirements to adopt regs that define representative samples of each lot to be tested and implement the ASTM international standard. Also delineates total aggregate weight of all representative samples to be collected for testing from the lot. The problem with, I guess the problems they had with this bill was it states in the bill must align with the ASTM international standard. And that standard is really clear on what's to be tested. It's 15-pound lots. You take 60 grams, mix it together. You take 20-gram testing samples. You have another 20 gram as a retesting sample and another 20 gram as a future testing sample in case you wanted to have it tested by other facilities. We created a process to help them out that if they thought this was too much, that if it passed testing, we would return the 40 grams extra. Again, that's a business decision if they want to do that or not. Again, we got a lot of pushback from both sides. Labs said it wasn't enough. Industry said it was too much. So we submitted the language as is, as aligning with the standard, and we'll see what happens in the next 6 months. AB 504 interview. AB 504 established provisions relating to deceptive trade practices in the sale of certain hemp products. This required signage indicating businesses are not licensed cannabis establishments. It also required signage indicating that all hemp products for sale contain less than the legal limit of THC, and it prohibits advertising hemp products as cannabis products or that hemp products produce an intoxicating effect. There's a couple examples of the signs that are approved that meet the requirements. Enforcement on AB 504. Again, so far in Northern Nevada, we've done 11 compliance checks and 9 of which have had violations. Southern Nevada, which this includes almost all the smoke shops and hemp shops down on Fremont. We had 12 compliance checks have been completed, 4 of which had violations. Upon recheck, all establishments had corrected their violations. There's not yet been a cause to refer an establishment to the Attorney General's office for complaint or civil penalties. Future, our current challenges, the federal landscape. Again, Nevada's cannabis industry continues to face significant challenges with the current federal landscape, including restricted access to traditional banking, federal tax restrictions under IRC 280E, and ongoing uncertainty surrounding federal legalization and interstate commerce. Also, just recently, there was a federal order on rescheduling of medical marijuana issued by the U.S. Attorney's Office. And there is a hearing set for the end of this month on the rescheduling of marijuana as a whole. Right now, there's an order. The order on rescheduling for medical marijuana is being attacked through litigation for being procedurally improper, that they haven't gone through all the administrative requirements. But regardless of that, we still have the actual hearing starting at the end of the month, regardless on all marijuana. Also, we have the same old problems, the illicit market, unfortunately, the unregulated cultivation, production, and sale of cannabis. 2027, looking ahead, we're awaiting findings from the Cannabis Advisory Commission on hemp to see where we're potentially going that for next session. Illicit market, we're bringing forward a bill to broaden our CCB enforcement officers' authority to address unlicensed cannabis activity. Right now, they're limited to only illicit cannabis activity within the licensees. We're trying to expand that to allow our officers, and especially with their expertise in hemp and cannabis, to help local law enforcement deal with the illicit problem. SB 41 is being implemented. That's a tax bill. This requires CCB licensees to register with the Department of Tax for a cannabis tax permit before 2027. Department of Tax and the CCB are collaborating to prepare and educate the industry. Again, this just puts tax collection squarely under the Department of Taxation. As of right now, when we renew a license, we require every licensee to be up to date on their taxes or have some kind of tax plan drafted with the Department of Tax. And that's every year. And unfortunately, the way it's set up right now is if they don't have that, they potentially could lose their license whenever their license comes renewable each year. Again, under SB 41, this gives them appeals process and allows them to go through the standard process that tax uses for almost every other business. And again, federal rescheduling, looking forward to the outcome of the rescheduling order and the hearing. We are going to obviously keep track, and we are letting all our licensees know what we know, which unfortunately right now isn't a whole lot. They have put down almost no guidelines on how they're handling it with either the tax code or with DEA. So thank you for that. Do you have any questions?
Thank you so much. Members, do you have questions? Starting with Assemblymember Cole.
Thank you, Chair. Appreciate that. My question is on AB 504, the enforcement of the signage requirements. You had indicated that in Clark County, I believe you said there were 12 compliance checks with 4 violations that all were corrected. My question is, are these 12 inspections of 12, say, smoke shops, or is it 12 days of inspections going to multiple smoke shops in a day?
Unfortunately, no, these are just individual smoke shops or CBD shops. We have a schedule that's going to increase this. Anywhere from 30 to 50 each month for the next 6 months. Okay. Right now, the problem with this is we have 3 enforcement officers that are handling this, and 2 of them are on a DEA task force to the state. One, the I-15 task force, another with the I-80 task force, working with various drug issues. Again, helping local law enforcement with various drug issues, but primarily marijuana issues.
Okay. Thank you. Understand. And I appreciate the enforcement will ramp up. Thank you. Thank you.
Other questions? All right. Not seeing any further questions. Thank you so much for being here and for your presentation. That will close out agenda item number 8 and take us to agenda item number 9, the Secretary of State's office.
Thank you very much.
Hello, good morning. So sorry for the delay. Good morning. My name is Erin Houston, and thank you so much to Chair Scheibel and members of the committee. My name is Erin Houston. I'm very grateful for the opportunity to present today. I'll try to keep this as short as possible. I know you had a long morning. I'm the Deputy Secretary for Securities, and I'm joined today by Deputy Secretary for Elections, Mark Balashin, who will present a separate presentation on the Elections Division. But today, essentially, we are providing an update on the work of the Securities Division, current trends, our responsibilities, and kind of just to let you know that we exist and that we're here, frankly. Okay, Securities Division's primary responsibility is to implement and to enforce the Nevada Securities Act, which is codified as NRS 90. I like to describe our agency as a mini SEC here at the state level. We license individuals and firms who sell investment products and investment advice, and we also register the investment products themselves as securities. We have an important role in enforcement as well. When we investigate violations of NRS 90, we conduct compliance examinations and civil investigations and also criminal investigations. And then finally, we also regulate athlete agents and conduct investor education to help Nevadans protect themselves. Just to give you a little bit of an overview of the Securities Division staff, it's made up of 21 employees. It's generally divided into 3 sections. There's the registration and licensing team. They handle all of the licensing for investment advisors and broker-dealers. And then that team is led by the securities examiner. We have a civil investigations team and an examinations team that's led by an attorney who is our chief of enforcement. He can file administrative actions on behalf of the agency. And then we also have the criminal investigations team, which is comprised of 8 sworn peace officers. And I'm honored to head the division as the as the Deputy Secretary for Securities, otherwise known as a Securities Administrator. As I mentioned before, the division operates under the Nevada Securities Act, which is NRS 90. We also administer the provisions of NRS 91, which is the Commodities Act. I'm adding that just because it will probably become more relevant in coming years, given the federal landscape, which will shift regulation of cryptocurrencies from being considered a security in a lot of cases to now being considered a commodity. And just as a brief update, this is not on the slide, and my apologies, but in the previous, we only had 1 bill in the 2025 legislative session that changed NRS 90, and that was AB 75, which was the Nevada Certified Investor Bill. The Certified Investor Bill created a carve out for individuals who are not accredited investors who would like to invest in intrastate offerings, meaning it is sold by a Nevada business that is only selling to Nevada investors. Okay. Our licensing and registration team reviews applications for licensing of firms, and the majority of the financial services industry is licensed in some way through our division. So the examination program, which I mentioned as the civil team, is run through our civil investigations team. We conduct tri-annual compliance inspections of investment advisor firms and of broker-dealers here in the state. We review their supervision systems, books and records, disclosures, and advertising. And we also investigate any kind of a claim that we get from a complainant who files with our division, and we have civil investigations that are not criminal in nature. And when that happens, we can file a complaint and seek to have their license revoked or a civil penalty of up to $25,000 per violation. Just for some context, Nevada has more than 213 licensed sales representatives. Those are the people who sell for broker-dealer firms. And we have over 1,500 broker-dealer firms, 157 Nevada-based investment advisor firms. Those are just the Nevada-based firms. There's much more that are regulated by the SEC. This reflects a large and active marketplace requiring effective oversight. We also contribute pretty significantly to the state general fund. FY23 revenue totaled over $35.7 million. And for FY26 year to date, we have revenue exceeding $37.4 million. Most of that revenue comes from our sales representatives' licensing fees and from securities exemption filings. For our enforcement side, our authority to enforce comes from NRS 9570, which is a prohibition on securities fraud. That prohibits fraud, deceit, material omissions, and misleading statements related to an investment offer. It applies broadly to advisory services and securities transactions, and it's also central to addressing crypto fraud, Ponzi schemes, affinity fraud. Our sworn peace officers mainly investigate allegations of securities fraud, and when they are found, they recommend prosecution to the Office of the Attorney General. Each violation is a Category B felony. These are just some current trends that we're seeing now. Those include AI-driven spoofing scams, Ponzi schemes, and affinity fraud cases. Just to kind of go into a little bit of detail on those. Cryptocurrency fraud involves fake online platforms most frequently and promises of high returns with little risk. They rely on social engineering and misleading statements. Usually you'll see that in the form of a text message or somebody meeting another person in the comments section on the internet. Just as a common pattern that we see, the investors are promised an algorithm-based return from a trading platform that they'll be given access to, and they'll be trading in cryptocurrency, but then those funds are then diverted or misused, and then false account statements are provided to the victims of these cryptocurrency scams. So they will see a statement on an account that's completely made up, but it looks as though their investment is growing. And then AI spoofing scams, this is something we're seeing a lot more in the last year or two, but that's where fraudsters use generative AI to impersonate real firms, advisors, or public figures. Fake websites and AI-generated videos are increasingly convincing. I just had a complainant file a complaint with our office saying, that she had thought that she had received a text message from Coinbase. In fact, it was not Coinbase. It was completely made up by an AI spoofer. So she unfortunately utilized that link to transfer money, and that money was all gone. But it was incredibly convincing, and it's increasingly common that we see this. And then we still see your classic Ponzi scheme, your classic Bernie Madoff scheme where investors are promised returns, but then those returns are funded not from legitimate profits, but from new investor funds. They tend to collapse when new investors slow. And then I mentioned affinity fraud. That's when you have a fraudster who exploits trust within a cultural or a religious or professional group. I'm not mentioning that because it's anything new, but because I have a concern. Las Vegas in particular has so many different types of cultural and religious groups, and I've seen major harm perpetuated by fraudsters within those groups, within several communities here in Las Vegas. So I just raised this issue to the committee for your awareness that that's something that happens frequently in Las Vegas in particular. Okay, just some brief case numbers, just to give you a sense of the kind of numbers that we're seeing. In the last 2 years, the division has opened 189 criminal investigations. 65 of those are securities cases. 124 are election-related criminal investigations, which I'll touch on a little in a moment. We have 133 civil cases and then 93 compliance inspections. Again, all of the civil investigations and the criminal investigations that are securities related come from complaints that are filed by members of our community. This demonstrates a heavy and sustained workload. And this is just a chart that shows some of the caseload trends. It does fluctuate based on referrals. We tend to have a jump after every election cycle, as Mark will discuss. And then, as Mark will also detail, our criminal investigations team handles criminal referrals for elections fraud. Most of our election-related investigations, at least that come to my team, involve double voting or ineligible electors. There are some others, but those are the vast majority of the cases that we see. The elections cases are far less complex in terms of the scope of the investigation, but because of the high volume, they do take up a lot of our agency time and resources. Since July 2024, we've had 67 election-related referrals for prosecution to the Office of the Attorney General, and then 19 securities fraud referrals. We've had multiple convictions. A lot of those cases take a while to make their way through the Office of the Attorney General, so I don't have a complete count of what will actually wind up being prosecuted and the convictions that will result from those investigations just yet. On the civil side, division has issued 24 administrative consent orders or administrative orders based on a complaint we filed, where we've either sanctioned a licensee for a violation of NRS 90 or issued a cease and desist order. Between FY 25 and 26, we've recovered $222,000 in civil penalties for the general fund. We established the Victims Restitution Fund for victims of securities fraud. And we are hoping that we will get more funding for that securities fraud restitution fund in coming years, so we can help victims who have been defrauded recover a little bit. It's not going to be enough to make them whole, but something to at least get them on their feet. And then just some key takeaways. The Securities Division is essential for ensuring that the financial services industry functions without delay in their licensing and registration, and also for combating fraud. And I thank you for your time and open myself up for questions.
All right, thank you so much. Questions from members of the committee? I do have a question, and I'm not quite sure how to phrase it, about the AI fraud scams. And I'm wondering, certainly the technology previously existed to produce a false report, like the investment statement that you mentioned. Have we seen this increasing in recent years, or just becoming more sophisticated? Or has this been an ongoing problem since, people were first, became computer literate?
Chair Scheibel, thank you for the question. Erin Houston for the record. This has definitely increased tenfold in the last few years. I think, if I had to guess, it's because of the availability of generative AI for individuals who might not have had the tech savvy or the sophistication to produce that sort of technological requirement to create a false, like a lot of times it looks not like a paper statement, although we do see that, but most often it's a website that recreates what you would see if you logged into your bank app, although it's just they call it their own platform. The platform is entirely made up, but for the spoofing cases, it looks just like you would log into Coinbase, or just like you would log into, we had a Robinhood case recently. So they look exactly like the actual website created by the legitimate vendor or services provider. But I think because of the accessibility of generative AI and the sophistication of their overseas gangs who are very, very sophisticated at creating phishing scams, and people are targeted easily.
That was my guess as well. So I appreciate you elaborating on that. And do you think that there's any conversation or any purpose in trying to identify those AI companies that are, I don't know if assisting is the right word, but enabling, these individuals to create the fraudulent websites? Like, is there anywhere to go with that investigation, or is that like just a non-starter?
Well, thank you for the question again, Erin Houston, for the record. That is an excellent question, and that is the bulk of how our criminal investigators spend their time now. What it usually requires, is to have a tracing tool that can follow the cryptocurrency to see actually where it has wound up, and then also subpoena the website owners. I'm sorry for not knowing the technical term for how that would be described. 9 times out of 10, or maybe 99 times out of 100, those are all overseas. So it's difficult to obtain records from something that is not housed or maintained within the United States of America. So I know that there's a lot of efforts to have international cooperation between criminal agencies across the world, but unfortunately, a lot of where those crimes are perpetuated are in countries that are not willing to participate or communicate with that sort of level of coordination.
I mean, it seems like at some point there's very little, if anything, that can be done for victims here in the state of Nevada when all of the crime is essentially taking place outside of our jurisdiction.
Thank you again, Erin Houston, for the record. It is difficult from a prosecutorial standpoint, without a doubt. It makes a lot of our cases dead in the water. That being said, that's why we have tried to focus so much on investor education, getting out into the community, making people aware that these dangers are real. The spoofing is extremely sophisticated, and they only need a few seconds of your voice and your likeness to create an image and a likeness that sounds very convincing. And also to work with the agencies across the country that we know have been effective at having some sort of stop. We actually did have, in the last couple months, we were able to seize $20,000. It's not a lot, but there was a victim who had lost about $100,000 in an investment scam to a scammer in another country. And because we were chasing the funds so quickly, tracing those funds to a wallet where we were able to put a hold and a freeze on that account, and then the money was able to be forfeited and given back to this victim in that way. It was not the totality of what the victim lost, but that's why we follow the cryptocurrency as quickly as we can, and the tracing tools are so important, and the sophistication of our investigators is also really, really important.
Thank you. I appreciate that. All right, any other questions at this point? Okay, not seeing any. Thank you so much for your presentation and for answering my questions. That will wrap up agenda item number 9.
Thank you again, and I'll sit up here in case there's questions relating to criminal investigations for elections as well.
Sorry, 9A. If I were to turn the page, I would see there is also, well, I guess 9A is on the next page, and 9B. Do we have the same presenters for 9B? All right, go ahead.
Good morning, Chair Scheibel and members of the committee. Mark Vlashin, Deputy Secretary of State for Elections for the Record. Keenly aware of the time, I appreciate the opportunity to present along with my colleagues, Aaron Houston and Daryl Harris, who are down south. A quick agenda, less than a dozen slides, so I'm going to jump right into it. First and foremost, I want to explain why we are here. Secretary Aguilar asked Deputy Houston and I to come present to the committee simply because over the last 6 years, we've not been here before. Election officials across our state, the roughly 150 of us at the state, county, and city levels, work very hard to ensure elections integrity, extremely hard, round the clock, year round, literally in midterm years and off-cycle years to make sure that your vote counts and the individuals who are not qualified to vote do not, and the individuals who are qualified to vote only cast one legal ballot. And we realize that we've been doing all this mostly in silence, without this committee's awareness, as similar to what Deputy Houston mentioned a minute ago. I'm going to talk today. I'm going to clarify that I want to specifically focus on some of the complaint process and not talk a lot about the security measures that we have in place. We have system catches and safeguards in place so that, for example, if a voter votes in person, then goes home and decides through that terrible mix of a lack of integrity and poor judgment to mail a ballot in also, the system prevents the casting of the second vote. We're really not going to talk too much about the systems today, the cybersecurity, the physical security steps that we have in place, but instead are going to focus on the complaint process. You can see on the slide the number of complaints that we've received as an office. Used to hover around a couple hundred during an election year and then taper off during a non-election year, and that's simply no longer the case. The numbers continue to go up, which reflects both an awareness of the electorate and an interest by the public in how elections are conducted, why things are going on the way they are, but also there's definitely a spike in individuals who, again, simply I think, are not aware of the security measures we have in place and are making some bad decisions. This is also, again, tied directly to a constitutional right that we have. Article 2, Section 1A, Sub 11 of our Nevada Constitution specifies that a qualified elector has the right to complaints about elections and election contests, and to have those complaints resolved fairly, accurately, and efficiently as provided by law. So who actually is doing this? Erin Houston and her team, again, are a key component of that, and we'll start with the Office of the Secretary of State. Erin's post-certified criminal investigators, again, as she said, conduct the criminal investigations in the Elections Division, and this has only been since really the positions were created in the 23 legislative session and actually filled at the beginning of 2024. The Elections Division now has 2 dedicated compliance audit investigators, and I'll talk through the process a little bit here in a moment. But additionally, and this is an important fact that I wanted to highlight, we work very closely with our state and federal partners among the organizations listed on the slide. This is also a relationship that we do not only conduct the first week of every other June or the first Tuesday of every other November, but instead are again again, year-round discussions, that we keep communication pipelines open and make sure that we're flagging for each other differences and trends that we see in other elections. There were 2025 elections, for example, that happened in a number of states. We looked very closely at those to identify trends and possible impacts to the Nevada electorate and shared those with our colleagues. We also have the Elections Integrity Task Force. I do quickly want to explain that is a collaboration between state, federal, and local law enforcement agencies that the Office of the Secretary of State heads up, essentially. The Secretary of State, of course, does not have like tasking authority on other law enforcement agencies. It very much is a collaboration organization where we share best practices information. There's training that's offered to make sure that, again, offices are aware of both changes to our state laws as well as some trends that we're seeing. There's an unfortunate regional trend where if mail ballot drop boxes, for example, are being targeted in Oregon or Washington State, there's a possibility of that sort of action being leaked essentially into our state. And so by using the Elections Integrity Task Force communication nodes, we're able to make sure that those type of challenges and risks are highlighted very quickly across the state to both election officials and law enforcement agencies. Another big part of the EITF, and I think this is a good comparison, picture back in the 1980s or 1990s. If you had a ransomware attack or were hacked and you went to a local law enforcement agency to complain or report that, there's a good chance that law enforcement agency may have said, I don't even know what you're talking about. Don't really understand the nature of cyber crimes. But nowadays, of course, so many law enforcement agencies do have entire cyber units set up to support the public integrity and make sure that their constituents and the public are aware of the risks through computers, for example. We are increasingly getting to that point now with election-related crimes. It's not 5 reports of an election violation, only in an election year. The discussions, the issues that are coming up are important enough to your law enforcement agencies across our state that they are asking proactively for information and to make sure that those best practices are shared so that it's incorporated into their new officer training, which is great to see. So what is the process? It starts with an allegation. Those allegations typically come through an election integrity violation report. It's a formalized document that the office offers on our website, but they also come through phone calls and emails and others. The form itself is really intended to gather the information necessary to be able to start an investigation. Our civil investigators in the Elections Division are the first ones that receive, log, and triage those reports to make sure that if it's something it's a high priority and it needs immediate action, then they will do so. If there's others that are of a more complex nature, there's a longer time period and more analysis that ends up being attributed to those. We do have standing meetings with the Office of the Attorney General and the elections deputy, myself. We again, this is a weekly process. Again, year-round, essentially since 2021, we've stood this process up. And every Thursday, we've conducted that. Specifically to make sure that we're addressing in a systematic manner all of these different allegations. I mentioned the involvement of the Office of the Attorney General because I don't want anyone to think that we, sit there in the dark, my investigators and I, and kind of arbitrarily come up with decisions based on what we think the statutes say. The partners that we have with our Office of the Attorney General are very important parts of this because they look not only at the case law, but they help us, again, discuss, review, and try to understand the nuances to state and federal law to make sure that if something is just an education issue, that we treat it as such. But in some cases, again, and this is improved, as you can imagine, over the years, when it warrants criminal investigation, we appropriately refer those as necessary over to Erin and her team. When, again, after the initial receiving and triaging of the reports, there's letters of inquiry and gathering of information as the civil investigators dig into the details, almost always working very closely hand in hand with county and city election officials to make sure that we understand the nature of the challenge and concern. And then ultimately, again, either sending a determination letter that there wasn't perhaps a violation of Title 24, which is the 9 chapters of state law, or anything that falls under the Secretary's purview. In some cases, we'll send a civil warning letter, a letter that says, we see what you did. Here's the information, and while it may not rise to a level that meets prosecution, you need to know that we are aware of your actions. And this is a copy of this letter is going into your voter registration. Or lastly, again, criminal referrals, gathering up all the information that we have, providing that to Erin and her team so they can conduct a criminal investigation when appropriate. This process, as I mentioned, again, because we have the two civil compliance audit investigators, now part of the Elections Division team, only since January of 2024, we have gotten to a point, thankfully, where the two of them have worked so hard to mature the process that we've actually conducted, as part of our biennial regulatory review, the codification of this process in NAC 293. It'll be down at the bottom, but if you are patient enough to scroll all the way down, the LCB file number there also includes the changes. But the goal is to make sure that the public are aware of this process and the differences in how we conduct investigations in the Elections Division. So when I talk about triaging these allegations in the cases, this is the tiered system that we've developed. Starting on the top left, that the Tier 1 high priority Title 24 violations that are of an easy effort and then really of an urgency. A good example is if we get a complaint from an individual who has gone to his or her polling place that they have voted at for years, but the doors are locked. It's election day, and there's no voting appearing to go on, and frankly, they're upset about that. That's not the time to ask about the county resources or the county decision to have less polling places or budgetary constraints. That's the time when we need to provide that voter with the nearest location to a polling place so they understand how to exercise their constitutional right, period. Those are the sorts of complaints that when we get, my team will make immediate phone calls to address so that the voter, again, can vote in a timely manner before the close of polls. Moving down, again, there's some lower priority Title 24 violations that also, again, common issues resolved typically fairly quickly, questions about certain issues or challenges or other things that maybe aren't necessarily as time sensitive. Tier 3 and Tier 4, frankly, are some of the more common ones that we get, and I have some statistics on the second to last slide that you'll see. But ultimately, a lot of allegations that we get are simply not crimes at all, or even violations of state or federal law. A lot of them are flat out misunderstandings. Individuals, again, we've talked, and I know this committee has heard routinely that our state is very transient. A lot of folks grow up in other states, move to Nevada, and then experience their first election here and go, golly, this is different from what I remembered in blank. We'll get complaints. Why did I get a mail ballot? I didn't request a mail ballot, right? Simply identifying that the voter was unaware that Nevada is a universal vote by mail state, and every active registered voter will have a ballot sent to them without requesting it. So there ends up being a lot of voter education and outreach that we do through this process as well. Looking at the top right, the Tier 1 high effort type of complaints, these are, again, maybe a little bit hard to read, but complex, time-sensitive issues that require extensive research analysis, discussion across a number of entities, and it may result in a criminal referral. I won't give any specific examples, but you can imagine a complex campaign finance case that alleges extortion or fraud of some sort that would require months and months to research and interviews. Those are important, but also not the sort of thing that we're going to resolve in an hour and a half or before the close of polls. But we do get the full spectrum of complaints across the tiered process that we have here. Some of the common allegations, again, just to show you, and I know that some of you were very familiar with these. I mentioned that first bullet again, just to drive home the point. A lot of them really are just misunderstandings. Opportunities for us to talk with members of the electorate, to explain how our state laws work, why, in many cases, we'll show how to get to Nellis so they can watch the discussions between legislators over the last few years that led to the decisions for bills to be passed that the governor signed. Again, that education piece has been extremely helpful and very integral to what we do in the Elections Division, especially when it comes to compliance. But when there are violations, they're generally found in 293-700 to 840. Or over in NRS 294A. 294A, of course, is the chapter of law that talks about campaign finance, allegations about an individual not submitting a contribution and expense report, a C&E report, or maybe leaving something off. Those are the sorts of investigations that point back to NRS 294A. But otherwise, in 293 specifically, there are a couple that tend to be more common than not. A little hard to read, so I'll cover them, but NRS 293-775 is voting by person who knows he or she is not a qualified elector or voting using the name of another person. 293-780 is voting more than once at the same election. Again, Nevada law does state that it's against the law to vote or attempt to vote twice at the same election. And then NRS 293, 800, unlawful acts concerning the registration of voters, violations of law governing elections, and crimes by public officers. Questions relating to voter registrations come up quite a bit, at least from an allegations standpoint. I do have some statistics here that I would like to highlight, and I think it's important also when you even just look at 2025, right, as a kind of a gentle reminder, we didn't have elections in 2025, but we still received over 1,300 elections integrity violation reports relating back either to the 2024 election or otherwise. Of those, approximately 6% ultimately wound up as a criminal referral, again, covering a number of different topics. I have included some trends there also, so you can see, again, residency challenges, the idea going back to, again, an improper or an allegation of an improper voter registration. There were some about campaign finance in 294A, 79 of them. The Electronic Registration Information Center, or ERIC, is an organization that Nevada was a founding member of. The ERIC program is a multi-state collaboration where at the end of a general election, states share through a very secure process where we hash our information independently, and then there's a comparison. But we have an opportunity to find out if somebody's voted or attempted to vote in multiple states across the country, at least through the member states, the roughly 26 state members of that organization. You can see that through ERIC, again, our membership in that organization has led to the identification of a number of alleged double voters who, again, were purported to have voted both in Nevada and in another state. There were some other alleged double voters that we came across through our secure systems that I mentioned earlier in the presentation. And then lastly, a number of ineligible elector and an attempted double voter. And again, that attempt is such a key word here because the vast majority of individuals who do attempt to vote twice, it gets stopped by the system, right? They vote in person, like I said, mail ballot gets turned in, or they mail in the mail ballot first and then try to vote in person, and it immediately flags that and stops the second vote, and that becomes Exhibit 1 as part of their investigation. That also, again, typically leads to a pretty significant amount of voter education, as you would imagine. But again, I want to drive home that the process is secure and that there are not just people out there voting illegally. That would be abhorrent to all of us. 2026, again, I have the statistics as of the 1st of June. Again, no criminal referrals yet, but we have received about 95, and I suspect, as I recall, just given the amount of work that we talked through on Thursdays, that number is upwards of closer to 200 at this point, frankly. Also, again, very similar type trends. Last slide before we get to the questions. I do want to just highlight that there's a way forward. The Office of the Secretary of State, again, not only do we take elections integrity extremely seriously, but through the not only appropriation of outreach budgets from the legislature, but also the creation of new positions. Again, the two compliance audit investigators, and there's an additional criminal investigator that the legislature approved even recently in the 25 session. These have allowed us to take huge steps forward in making sure that elections allegations are investigated in a timely manner. But we're very much a pleased but not satisfied organization. While we're happy at the huge leaps and bounds we've made, there's still work to be done. We still intend to increase our outreach with the county district attorney and local law enforcement agencies, right? There's continued turnover, promotions. The folks that we worked with in 24 are not the folks, for the most part, we're working with in 26, and they won't be for the 28 presidential cycle. The increased outreach and education of voters, right? The more folks who are simply aware of the system catches that we have, that the efforts that we make, that across the board, I'm confident that there will be less attempts by individuals to either check the system, quote unquote, or again, demonstrate that poor judgment and attempt to vote twice. So that absolutely has to continue. Further standardization of processes, instructions, and guidance. We have a lot of poll workers across the state, right? Somewhere between 2,000 to 4,000 poll workers are involved and really required for an election. Great individuals, all of them. How we train them every other year at the county level, again, still could use some improvement. We want them to be able to pass on correct information to voters when they show up. We certainly don't want somebody that's a poll worker to say, for example, no, it's okay. You can, if your ballot hasn't arrived yet, you can still vote in person. The system will just block it. Not aware, perhaps, that is a crime they're talking about. So there's still some improvements internally that we're going to continue to look at and apply, both to the 26 as well as the 28 election cycle. There's additional opportunities, of course, also for some further security enhancements. At the end of the day, if our systems can block, prevent, warn individuals about what their actions are going to be, again, I think that there's opportunities that we should be taking, and we're looking into those. And then lastly, 293.840, NRS 293.840 identifies that in addition to any criminal penalty, a person who violates the provisions of this chapter is also subject to, or may be subject to, a civil penalty in an amount not to exceed $20,000 for each violation. That process we are working closely with the Office of the Attorney General to develop specifically so that perhaps certain individuals who continue to test the system, who continue year after year to attempt to vote in multiple states or to test the system in person, by mail, and otherwise, may benefit perhaps from a fiscal fine to remind them truly that our elections need to be as clean and pure as possible, and that the violation of the integrity of our electoral process is not a laughing matter or something that we take lightly. But again, that has not yet been developed, but it's something that we're looking very closely at. That being said, and looking at the clock, I want to respect your time, but I'm available for questions if you have any.
Well, thank you so much. We certainly appreciate you making yourself available and for that presentation. Are there questions from members of the committee? I don't see any in person. Do we have any questions online? I know that you covered this, but could you just reiterate, have there been any criminal prosecutions for voting violations in the last 10 years?
Thank you for the question, Chair. Mark Voloshin for the record. I'd like to ask if I could, if Deputy Houston would mind addressing that one, seeing as how she deals with the criminal referrals more directly.
Yes, hi, Erin Houston for the record. Happy to provide specific numbers for the last 10 years. I don't have that number in front of me right at the moment, but there have been, I want to say, several to maybe 10 prosecutions over the last 10 years. That's a guesstimate. They have resulted from various charges. For the most part, they're voting twice in the same election. At least, 9 of the ones I'm thinking of were the Office of the Attorney General, and then the 10th would have been the U.S. Attorney's Office. And I can provide specifics if you would like those.
That's okay. I was just trying to get a general sense for, how common these were. And you gave us a good idea of kind of how common this is, but then also the funnel, right? How many actually result in criminal prosecutions? So.
If I may, Erin Houston,
Please.
for the record, we find that they're difficult to be accepted for prosecution because of the unavailability of the actual ballots themselves. So because of the fact that we just don't have a lot of the evidence we might need, those cases tend to be difficult to prosecute. But the vast majority, again, just to reiterate for the record, are mistakes and not intentional, and they're attempted double votes, not completed double votes.
Thank you. I appreciate that clarification. All right. If we don't have any other questions from our members, we will thank you again for joining us on this Tuesday, and that will close out agenda item number 9. And that takes us to our lunch break. Hold on just a second. All right, my committee wants to eat fast and get back here. So we're going to be back at 12:45. We will see you all then. All right. I will call this meeting back to order of the Senate Judiciary Committee. We are on agenda item 10, I believe. We're going to hear from some sections of the State Bar, starting with the family law section. I believe these presenters are on Zoom.
Yes. Hi, Melissa Exline, E-X-L-I-N-E. Chair Scheibel, Vice Chair Miller, members of the committee, thank you for the opportunity to testify today. I do have a very short presentation to provide updates regarding the implementation of recent legislation. And with respect to future 2027 changes at this time, the Nevada Family Law section of the State Bar doesn't have anything that's specifically being put forward by the section. However, I have some information on ideas that people have thought through to some extent, and I'll provide an update on where that stands, although there's nothing on the table at this time. So with that, I will do a slideshow presentation very briefly, if I can here, to get that going. Just give me 1 second for that. Okay, I believe that's on there, but I'm not really sure at this point. Hold on 1 second. Okay. I can't tell if there's a slide on there or not at this point.
We are able to see the slide.
Okay, perfect. Oh, perfect. Okay, so what we have here with respect to the, let me just get this going here. Okay, so what we have here is there's 3 main statutes that went through with respect to family law from the last session, and I'll just provide a very quick update on those. The primary one that I think is notable is SB 275, making changes to NRS 125C, which is the primary child custody statute. And within that, it's been codified, SB 275, into 125C.243. What this talks about is some changes with respect to allowing a reunification work in a child custody proceeding. If the parent is alleged to have committed domestic violence or child abuse, there was some discussion about, limiting expert evidence, and it can only be admitted if there's a substantial clinical experience and it is not primarily of a forensic nature. The court shall consider arrests or convictions for domestic violence or child abuse. Obviously, that makes sense. They also are to consider if a party has had an order for protection or a restraining order, and shall not issue an order to remediate the resistance of a child to have contact with a parent unless, and then there were very specific circumstances, unless the order primarily addresses the behavior of the parent with whom the child resists and requires the parent with whom the child resists contact to take action to remediate the resistance as a condition precedent to the other parent of the child to take any action to improve the relationship. So this one is a bit of an interesting statute. I'm not, right now, the way that the courts are handling this is kind of still unfolding on a case-by-case basis. I think a lot of orders for parental reunification had been issued before this statute had been put into effect. When you go into 125C 245 2 and 3, one of the things here, it says that it defines what forensic means when it's limiting forensic experts, and it says means provided pursuant to a court order for the purpose of litigation, and it includes without limitation the evaluation of a parent or child involved in a child custody proceeding. One thing that's notable is that could actually prevent a police officer or a social worker as part of Washoe County Human Services Agency or a Child Protective Services Agency of some sort from giving testimony. So the statute is a little bit problematic, and I think that the courts are still just addressing what that might look like as far as implementation. So the status of this is that it's got very strict limits between a parent and child on how the reunification should unfold. There's a lot of concern on what this will look like and how they can thread the needle for compliance with the statute. And I think that this one might be ripe for things to be changed or maybe cleared up, just tidied up in the way that the statute was written. I know there was a lot of emotional testimony provided as part of the background for this particular statute, and it did pass in its current form. So the main takeaway at this point is that the impact is not fully realized at this stage. The next one's SB 432. This is part of Chapter 121, and it repealed two statutes. This is related to a Supreme Court decision called Falcone. There's been some decisions where the Nevada Supreme Court was ruling that we needed to make sure that the courts had discretion and evaluated open courts, didn't just outrightly seal cases, so that we provided appropriate transparency of the judiciary. And so this was addressing some of that case law. To some extent, it codified the actual rulings within the Falcone decision. But what it did is the case law has actually ruled that what was previously NRS 125.080 and 125.110 were unconstitutional. And so now we have new statutes 121.050, 121.100, and 121.110. So these are brand new. And I'm sorry?
I'm so sorry to interrupt you, but the slides are not changing.
Oh, they are not.
No.
Okay. Let me just see. I have a slideshow, and then it's, let's see if it's working. Okay, let me bring that up for you. So I appreciate the interruption. So here was the 275 discussion and some of the changes with respect to that. But here is where we are right now. Is that coming up? Thank you. I appreciate it. Melissa Exline for the record. I appreciate it, Chair Scheibel, very much. Okay, so the 121.050 defines what family law proceedings are, and that's important because this is applying to the family law cases. And to provide a little backdrop, it seems kind of like a no-brainer. We're dealing with family law cases, but typically a lot of family law matters that are in this zone were already sealed. For example, adoption cases, child dependency cases where children are removed. Those kind of cases have privacy already, kind of a blanket is thrown over them, so to speak. And so this is differentiating divorce and custody cases from those other types of family law cases. It does allow the courts to seal or allow certain things to remain private. So for example, protected health information, education records, things that are typically already under privacy statutes. And then this also clarifies that not everything is open to the public, but it gives us clear guidance that's in line with the statute at this point. So what I can tell you is that the courts are right now taking specific time to weigh and exercise their discretion. In my own experience, I'm seeing hearings being held so that the law is complied with and the statutes are balanced against what the Nevada Supreme Court ruled on in the Falcone decision with respect to presumptively open courts. I do think it is taking quite a bit of time, and I think it might bog down some of the courts, but that's where we sit at this point. The next big update, and I'm going to kind of provide this just generally speaking, is the adoption law, which was SB 227. This is so comprehensive that I didn't make a bunch of slides on this to just walk you through what happened. Overall, this was a modernization of the adoption language and was basically a top to bottom rewrite of the adoption statutes, which were in NRS 127. It has now been broken up so that the information with respect to adoption is a bit more clear. There was very old statutory language in the prior NRS 127 before these changes, It essentially allows and clarifies your standard adoption where someone goes to an agency, wants to adopt a child, how that works. And then it clarifies and breaks things out versus a close family adoption, differentiates between adoptions through the system, through the child welfare system, or if you're doing an adult adoption, things like this. So it kind of breaks it out into very clearly identifiable types of adoption, and was a top to bottom rewrite of the entire statutory scheme. I know that the courts are looking at this and digesting the appropriate ways to handle this. But overall, it was taking what was being done and put words to our legislative scheme so that it was clearer on how to follow the law. The last bit I will put out there is that there is now equal treatment and clearer language with respect to biological mothers and fathers in the process of relinquishing their children for adoption, providing consents, and how that worked. That had sometimes involved litigation when there were disputes about the validity of a consent versus the validity of a relinquishment and what that meant, because those are two different things. Now we have clearer language, so that was a good thing to put in place. There were some changes with respect to guardianship law that were proposed. Very modest changes went through. I anticipate that there will be guardianship law changes brought forward next session by folks, but I am not unaware of where that sits at the moment. What I do know is that the family law section has not been approached to put forward any specific statutory scheme with respect to guardianship changes. What I'll say too is, so members of the bar and mental health professionals have voiced concern about some of these areas. One last thing, and I don't have a slide on this, I just wanted to let the committee know that as far as I understood it, is that the sections of the state bar were advised that they had a hard deadline of July 3 to provide any proposed section-based statutory changes so that could be appropriately circulated within the state bar. The sections do not like to put forward section-based law that lacks consensus. So if not everybody's on board and people are arguing, well, the pros and cons of this are one thing, pros and cons of that are another, then we generally will not be putting that forward as a section, for a statutory change. But the July 3rd deadline is still there, so there is a likelihood that something could still drop or people could put something forward. I know that there has been some general discussion about a desire to change when the community ends. And so when right now under Nevada law, the community, as far as what counts as part of the overall assets and debts for a divorce, ends when the decree of divorce issues. And in other states, for example, California, they put forward the community ends on the date of separation, and then that is often litigated as to when did we really separate? What do we mean by that? So there's pros and cons. Different states do it differently, and it's been a bit difficult to litigate the end of a community when your end is still unfolding and you don't have a deadline yet. So it causes issues in judicial proceedings at this time. So some people have expressed a desire to do that, as well as changing some spousal deeds and the impact of signing a spousal deed on real property. And to provide a little bit of context on that, a spousal deed is something that is often required if one spouse qualifies for a home, they want to refinance, but the other spouse may not have good credit. This is just one example. So they'll put the house and the loan in just one person's name. Well, at divorce, they might pull out the deed and say, well, you gave that to me, the house is mine. And so there's a more difficult and detailed analysis as to whether that was intended to be a gift or not. And there's been some appetite to streamline that language and make it more clear and more fair rather than getting embroiled in more detailed litigation. So that's the overall update on kind of where things stand. The section itself does not have anything that's being proposed for the future at this moment, albeit something could come down in the summer, in which case we would update anybody interested in that right away. And again, that's pretty much it for me. I'm chair of the family law section this year. My name is Melissa Exline, and I appreciate the opportunity to speak, and I'm happy to take any questions.
Thank you so much for that presentation. Do we have questions from members of the committee? All right, I don't see any questions up here. Do we have any questions in Carson or online? I don't see any. Well, we certainly appreciate the update, Ms. Exline, and we appreciate you being here with us today. That'll close out the presentation from the family law section, and we'll move on to the probate and trust law section.
Here we go. Good afternoon. This is Michelle Rafferty on behalf of the probate and trust section of the Nevada State Bar, along with my co-chair, Jeff Lushak in Vegas. We serve as the co-chairs of the legislative committee for the State Bar section and are pleased to be invited to appear here today. Well, what we wanted to do today is to give you a little bit of background on what we're working on for the next legislative session, as well as sort of a state of the state of the trust section for the state of Nevada. One of the things that is often surprising to individuals when they learn this is that Nevada is right now one of, if not the leading jurisdiction for trust law. Across the United States, we serve as a role model and a beacon for where many people want to come and establish not just residency, but their trusts, whether they live in Nevada or not. And so our laws have become one of those things that are looked at not just here in Nevada, but by courts all over the world, particularly throughout the United States and through Europe and the Middle East as well. So we are right now that jurisdiction that is definitely in the forefront. What our committee does in this particular case, and we've done this now since back about 2002, is that we gather together as a group of practitioners who practice in the area of probate, trust, probate and trust administration, as well as estate planning, taxation, and we work on that area of law that affects those individuals in the trust and estate field, but it really is much broader than that. We address real estate, assets, transactions, family law aspects, everything you can imagine that occur inside of a trust administration, inside of a family business, and all of those combined with both the IRS concerns and with state law issues as well. So it really does affect everybody throughout the United States and throughout our state, particularly in regards to these particular laws that we look at. The committee is charged with gathering not just the laws that we have today and seeking to improve them, but also developing new areas of law that are impacted by technology. Such as an example would be electronic wills and trusts, which became very popular during the COVID era, in addition to looking at areas where we're dealing with Bitcoin and dealing with Bitcoin in estate and trust administrations. All of these technological advances have to be addressed in our probate and trust codes as well. So it really is a very active committee. Particularly how we look at putting our legislation together is by gathering a group of practitioners. Now these practitioners are all volunteers. They come together from various aspects of the state bar. Some of them are solo practitioners. We have people from the rurals, people from the cities, large firms, small firms, all across the board, and they're given the opportunity to come forward, bring legislation, ideas, and areas where they're experiencing either concerns or an absence of law in this area in the courts throughout our state. We work together in a workshopping forum and then ultimately work through passing that legislation through our committee process. It then goes on to the State Bar of Nevada. all sections of the state bar are able to review the proposed legislation. And then once we've had comment and or any changes are made to it, the state bar, assuming that they bless us, then we will come forward with our bill. And this is what we've done just about every session since 2002. Thankfully, this committee has been incredibly gracious to the bills that we've brought forward, given that our area of law tends to be bipartisan and tends to be very much impactful on the citizens of Nevada. It has really been very, very well received, and our legislation has been very successful. Just this last session, we did pass a bill that has been moving through their system. The courts seem to be working very well within the new sections that were passed last session, and I am pleased to report that it does not appear that we have any of the sections that we passed last session that are problematic, and so we will anticipate moving forward with those and bringing forward new provisions. I thought I would walk through some of the proposed legislation that we're looking at. I want to caveat that this has not been passed by the state bar yet, and so there may be some modifications to these general areas. But I'm going to start and turn this over to my co-chair, Jeff Lushak, who will walk through some of the probate and litigation-directed sections that we're looking at for proposals for this coming session. Jeff?
Thanks, Michelle. And thank you to members of the committee for having Michelle and I here today presenting what we're hoping to accomplish with the Probate and Trust Legislative Committee this upcoming session. And as Michelle said, the practitioners in the trust and estates field in Nevada, they are very active in our legislative committee. And our legislative committee does address a number of topics that are not necessarily what you would think are involved in the estate or trust field, such as business succession, real estate, tax, those types of things. And we're also very inclusive and accept suggestions from other members of the community and in other professions. For example, as we've been gearing up for the 2027 legislative session, there's been at least one realtor who has come to the legislative committee and said, hey, I've identified some issues that I see in the sale of real estate in a probate proceeding. Would you consider kind of these modifications or amendments to these statutes? And we've spent at least one, probably close to 2 sessions, just going through those issues that he sees from a real estate professional, and to see how we can implement that in making the probate process easier. One of the kind of a hot topic from the 2025 session and something that we've been addressing for the 2027 session is the Uniform Healthcare Decisions Act. If you recall, during the 2025 session, in response to the passage of Assembly Bill 461 with amendments, also known as the Uniform Healthcare Decisions Act, the Nevada Supreme Court chartered a guardianship commission, the Nevada Supreme Court Guardianship Commission chartered the establishment of an AB 461 work group to further examine the Uniform Healthcare Decisions Act and to make recommendations to the full Guardianship Commission. The Guardianship Commission will then present its recommendations during the 2027 legislative session. Specifically, the following were the two objectives of the AB 461 work group. One, to examine certain aspects of the Uniform Healthcare Decisions Act, and 2, to provide recommendations to the Joint Interim Standing Committee on the Health and Human Services in writing or at a meeting to the committee regarding its examination. Some members of the Legislative Committee were invited to participate in the AB 461 work group, and I believe the AB 461 work group is in the process of finalizing those recommendations and providing those to the Guardianship Commission. Moving on to some changes that we're hoping to make in the probate field. One of the major topics is providing uniformity in how judges in different districts throughout the state rule on different issues. And one example with that is in probate proceedings, attorneys can be paid a number of different ways. Attorneys can charge a statutory fee, which has been approved by the legislature, or they can move for hourly fees. And one of the changes that we're hoping to make is modifying how different courts throughout the state of Nevada look at that. For example, there could be a court in Washoe County that interprets a statutory fee one way, whereas a court in Clark County views it another way. So we're hoping to resolve any issues regarding that. So we'll have uniformity throughout the state, and we won't promote kind of form shopping for people going to jurisdictions that they believe will be more beneficial to them. Another issue is Nevada, like many other states, litigants in civil or criminal proceedings have the right to appeal a judgment or an order disposing of a matter within 30 days of the notice of entry of order. In probate and trust proceedings, it's a little bit different. A lot of orders that are issued by a probate court are immediately appealable. And the reason for that is certain decisions that a probate court judge may make in a probate matter or a trust matter. And there are some trust proceedings that have gone on for decades in the state of Nevada. I think my office may be involved in a trust proceeding that's been going on for 30 years. So obviously you don't want interested persons involved in those cases to have to wait 5, 6, 7, 10, 20 years before they can take up issues that may affect them with the Nevada Supreme Court. So NRS 155.190 specifically identifies specific issues that could be appealed to the Nevada Supreme Court immediately without having to wait for the administration or the litigation to be finalized. For example, if a will is admitted to probate by a probate court judge, that's an issue that currently can be immediately appealed to the Nevada Supreme Court. Granting or revoking letters testamentary, that's an issue that could be potentially immediately appealed to the Nevada Supreme Court. So there's a number of different exceptions in there that allows a litigant immediate right to appeal to the Nevada Supreme Court. And what we're hoping to accomplish this next legislative session is just clarifying some of those areas and adding a little bit more just to provide for benefits to the interested persons involved in these cases and to promote clarity. Another issue that we want to fine tune and clarify a little bit relates to the effect of divorce in estate planning documents. Currently under NRS 133.115, in the event of a divorce or annulment of the marriage of a testator of a decedent, that revokes every devise, beneficial interest, or designation to serve as a personal representative to the testator's or the decedent's former spouse. Currently, as written, though, there's some ambiguity with respect to relatives of the former spouse. So, for example, if a deceased person obtains a divorce from a wife or a husband, they would not be eligible to serve as a personal representative of the estate. They wouldn't be entitled to receive a distribution under the current estate planning documents. However, the former spouse's mom, dad, or other relatives may be able to benefit and serve in those capacities or receive a beneficial interest, where most likely that's not what the decedent would have wanted. It was likely just due to an oversight. So we're hoping to clarify that it's not just the former spouse, but it's relatives related to the former spouse, and we're going to specifically identify who falls in that category. Another issue that practitioners in the trust and estates realm deal with a lot is who are entitled to copies of trust instruments and when are they entitled to trust instruments. And we have a statute already that deals with that. It's NRS 165.147, but there's a disagreement amongst practitioners as to what does that include. If after a settlor of a will passes away, and the beneficiaries of the will are entitled at that point to a copy of the trust, what does a copy of the trust mean? Is it just the current version? Is it prior versions? Is it amendments, things of that nature? And we're hoping to kind of fine tune that to confirm that what they're entitled to is a current copy of the trust and not all the prior iterations. And the last thing that I want to talk about that we will be proposing is, and this goes back to the concept that Michelle talked about, is Nevada is really a leader in the nation in the areas of trust and estates. And it's not uncommon for people to come to Nevada throughout the United States to create trust and to take advantage of our laws, our unique laws, and throughout the world. But in so doing, that creates some problems in that you have people, that come from New York or, Minnesota. They create these Nevada trusts, and you have people that live outside of the state that are trustees, that are trust advisors, and that are trust protectors. And that sometimes creates a jurisdictional quagmire, right? We have a Nevada trust, but the people that are running the trust reside outside of the state. And currently we have a statute 163.555 that makes it clear that a trust protector or a trust advisor, if they accept that appointment, then they are subjecting themselves to the jurisdiction of Nevada. And we're amending that statute to kind of further clarify that trustees as well that accept the appointment as serving as a trustee of a trust, they will also be subject to this jurisdiction of Nevada. So if some type of administrative or litigation proceeding is filed, if they're residing outside of the state or in another country, they can't say, hey, sure, I know that the court has assumed jurisdiction over the trust in Nevada, but it doesn't have jurisdiction over me because I don't live in Nevada. So that's another issue that we're hoping to address. And again, that is because Nevada is this destination for these specialized trusts that is allowed under Nevada law. So that is all that I have. I'm going to turn the time back over to Michelle.
Thank you.
There we go. Michelle Rafferty again for the record. Thank you, Jeff. And turning back to just a few of the additional items that Jeff dealt with the probate trust administration area and a little bit of litigation. I will go back to some of the estate planning items that are on our list of items that we expect to present forward to you. Currently, what we see is trusts that are going on for multiple generations. We have the ability in Nevada with a rule against perpetuities of 365 years to have some of these trusts going on for a very long period of time. It becomes very difficult to draft trust documents that are in a condition to be able to withstand that test of time if they have too much detail in them. And so therefore, a lot of the trusts today are being drafted in a way that are designed to withstand the test of time without a lot of specificity and without a lot of detail. One of the areas that creates problems, though, for is trustees not having enough guidance and information, at the same time trying to balance not having trust agreements that are 200 pages long and look like a manual rather than a trust instrument. In order to move past that, one of the things that is happening is the ability for grantors, for testators who are putting trusts together, to be able to do separate side letters, letters of wishes, letters of guidance to their trustees that aren't necessarily part and parcel of the trust agreement itself, and giving trustees some bandwidth to be able to consider those wishes of the grantors in those letters of wishes. So we do anticipate bringing forward a section that several other states have also already adopted, and we would anticipate a similar provision allowing trustees in the state of Nevada to consider a settler's letter of wishes when administering a trust. It would be non-binding, of course. The trust agreement itself will control, but it will provide some protection for trustees in considering the information that's set forth in a qualified letter of wishes within the state of Nevada. The other area that we're seeing with these long-term trusts is the ability to have designated representatives. A lot of our trusts these days, because of the way that they're structured, they do have restrictions and parameters on accountings and disclosure information. Jeff mentioned the ability to retain some aspects private and not have to share significant portions of trust instruments. That's wonderful from the standpoint that the grantor may wish to keep some things confidential. It can be difficult, though, for our trustees throughout the state trying to administer the trust and having nobody for whom they can give an accounting to, since accountings are how trustees relieve themselves of liability by providing disclosure of what they're doing. One of the concepts that is now available in several states is the use of a designated representative for the purpose of accounting and providing accounting and information to through the trustee. That aspect we have already adopted in Nevada. It is specific for Nevada family trust companies, but it hasn't been expanded to our chapter NRS 163, and we're looking to expand that so it won't just be applicable in the family trust company context, but also throughout all of our trust administrations in the state. In addition, we have been working on our notice of proposed action. And again, this is a very special provision we have in 165.725, which allows our trustees in Nevada to give notice to individuals and be able to provide them with transparency of what they're doing. And assuming that nobody objects to that notice and does not come forward to indicate a problem, the trustee can then proceed forward to take the proposed action that's been disclosed without having personal liability. Now, it doesn't always mean that the action being taken is necessarily the best action or the best choice, but it is a mechanism of giving the beneficiaries an opportunity to have disclosure of what's occurring, giving the trustee the ability to clear off some of that liability and risk that could go on in some of these trusts for many, many decades. And so it is a way to help our trustees get closure on their exposure for ongoing liability. In doing that, although we have that statute currently, it is not broad enough to cover the scope of beneficiaries and individuals that perhaps could be given notice. Currently, it only refers to a specified category of adult beneficiaries. It's not expanded to include the settlor themselves and the ability of a trustee to give the settlor of a trust notice or other advisors. And in the same, it's also not expanded for other types of fiduciaries in a trust administration to give those same sort of notices. What we are going to propose is looking to expand that so that disclosure can be given, and then the individual giving that disclosure would be entitled to those same release benefits, as well as the people receiving them would have the opportunity to have a say and perhaps to object if they're dissatisfied with the actions that the trustee is proposing. So I'm very excited about that legislation, as I think it will really provide a lot of additional resources to our trustees throughout the state. I think that will also have some impact on the ability to have some closure of various matters without always having to go to court to get court instructions and taking up judicial resources that are so precious. So this gives us an alternative to some of the court activity that often has to occur when we have no other choice in order to relieve our trustees of fiduciary liability. And then finally, I just wanted to touch on, we also are looking to expand the language with regard to our unique category of trusts in Nevada called the Purpose Trust. Usually a trust, in order to be valid, has to have beneficiaries. But we have in Nevada a special category called a non-charitable purpose trust, where an individual can form a trust for the purpose of any purpose that's a legal purpose set forth in the trust agreement without necessarily having to physically have identifiable beneficiaries. So the purpose could be a greater good for the community. It might be something that doesn't necessarily fall within a charitable category, but a good purpose for the overall purpose stated in that trust instrument. Right now, we have that statute, but it is a little bit narrow, and so we're looking to expand upon that. And I think that really covers what areas we're looking to address and cover. I'm happy, and Jeff and I are happy to answer any questions, anything that you might have that you'd like to ask about as far as past legislation or what we see coming forward. And I'll turn this back to you, Chair.
Thank you so much. Members, any questions? Not seeing any, and I don't see any from Senator Krasner. I will go ahead and close section B and then open up our final presentation for the day is 10C, which is real property law section. And so our presenters so our presenters will be on Zoom. So we'll just give you some time. We'll wait for you to appear. Okay. Do you have anyone else presenting with you?
No.
Okay, then please go ahead and introduce yourself and proceed when you're ready.
Good afternoon, Chair Seibel and Vice Chair and members of the committee. My name is Michael Buckley. I'm the chair of the real property section, and really appreciate this opportunity to make this presentation and address what I have. I've submitted materials that contain, there's 7 substantive changes or proposals and 7 technical changes. We usually address one item or whatever we can fit under the category of changes to real property law, looking to clarify or improve laws that practitioners have encountered. So the materials include that. Included in the materials are a presentation I made to the Board of Governors last November with examples of problems encountered in recording documents over the past 2 years in Clark County. Also the statutes that are mentioned, and a list of proposed changes to NRS 116 that are based on uniform law changes. And I'll repeat what the other 2 section chairs talked about, that we have to go through the process. We do have proposals that are consensus based, and we will be putting together a proposal for the Board of Governors to review I think our deadline is July 3rd, and go from there. But I'd like to focus on 3 areas, and and one of them, we have our executive committee meetings every month, and the topic that has generated the most interest in all of these meetings, and continues to generate a lot of interest, are problems recording documents, particularly in Clark County. And the examples given were a memoranda of agreements unless the recorder looked at the underlying agreement. We also had a situation where a financing statement filed as a fixture filing on the Secretary of State form was rejected because the recorder didn't like the description of the collateral in the financing statement. The problems that have come to light really are based on a 2003 amendment to NRS 247-145. Before 2003, practitioners and no doubt recorders also believed that recording was a ministerial act. What happened that gave rise to the 2003 amendments were people recording documents creating liens on property of public officials. The resulting legislation, NRS 247-145, permitted the recorder to reject a document if the recorder believed it was unauthorized, falsified, or otherwise may not lawfully be recorded. These are very broad categories. What does unauthorized mean? Does it mean that the person signing is not authorized, or that the corporation didn't adopt a proper resolution? Falsified seems to require some kind of forensic examination. And whether a document may not lawfully be recorded seems to call for a legal conclusion, which recorders are not authorized to actually give legal advice. The 2003 amendment also deleted without explanation an ancient provision, which still exists in California, that basically said that the recorder is not responsible for what the document says. It can't reject a document if the document doesn't accomplish what it's supposed to accomplish. We're not proposing any particular language. It may be that the law can make clear once again that recording is ministerial, and I have a cite in my materials for a Attorney General's opinion and a Supreme Court opinion that said recording is ministerial. But unfortunately, it was based on the statute that was deleted in 2003, but without explanation. But we believe that the current grounds for rejection are way too broad. And as a practical issue, a practical concern, a lot of documents are delivered at a closing. And if the recorder rejects a document, that leads to delays and expenses, and sometimes may even thwart a closing. And I don't think that anybody has that in mind. That's not a good result. So we're looking to have the recording laws, NRS 247, corrected. There was what's interesting is that the Uniform Commercial Code also was addressing a similar concern and covered it in its amendments in 1999. And basically what that amendment said was that, and this is NRS 104-95106-2H, which states that a financing statement is not effective if it lists a public official of a governmental unit as a debtor and the public official has not authorized the filing. So really the concern is that the reasons for rejection are too broad, and really the recorder shouldn't be in the business of examining whether documents accomplish their purpose or not. The second area, and it's sort of outside of our concern, but just wanted to bring it to your attention, and that is the mortgage company licensing laws. So NRS chapters 80, 86, 87A, and 88 exempt foreign corporations, limited liability companies, and limited partnerships that make mortgage loans in Nevada, basically if they are not located in Nevada or accept deposits in Nevada. And there are two concerns that we have here. First, there's an exception to the exception, and that is if the foreign entity solicits business of a mortgage company as defined in NRS 645B. And 645B defines a mortgage company as, among other things, anyone who holds him or herself out as being able to make loans secured by real property. So it's very, very broad. So soliciting or holding oneself out can mean many things. No one disagrees that a lender that comes into the state and makes loans ought to be licensed. But what about a company that's based in New York with New York offices, or Los Angeles, and in their office says that they can make loans in Nevada? Are these holding themselves out or soliciting loans as a mortgage company in Nevada? So we think that this definition, or the what it means to solicit or hold oneself out, needs to be defined. It could be by regulation or it could be by legislation. But this leads to the second concern, which is more important, and that is so becoming a licensed is time-consuming and expensive, and it's not unreasonable for an out-of-state commercial lender that makes a mortgage loan in Nevada every now and then to avoid licensing if it possibly can. Since soliciting and holding oneself out are fact-intensive, if a mistake is made, the penalty is very severe, or potentially very severe. Under NRS 645B.920, any mortgage transaction contract entered into by the violator is voidable by the other party to the contract. 3 appellate cases have addressed whether the mortgage loan itself can be voided because of a violation. In each case, the court avoided interpreting the statute and was able to decide the case on other grounds. But really, a legislative amendment to this statutory penalty is necessary. A better interpretation, and one in which we argued in an amicus brief to the Court of Appeals, is that the contract to make the loan can be voided, but not the loan itself once the loan is made. It may be even as well that loans of a certain size, a commercial loan of $1 million or some material amount, ought maybe to be exempt from licensing altogether, provided they're not located in Nevada. To conclude, foreign lenders making loans in Nevada are good for business. The licensing laws should be, number one, be clear on when a commercial lender has to be licensed, and 2, provide a penalty suitable to the violation, not something that is way out of line for the potential violation. And my final topic area is something near and dear to me. I've been involved with NRS 116 since its inception in 1991, working with Chairman Robert Sater of the Assembly Judiciary Committee to get the law passed, which was a 1982 version of the Uniform Common Interest Ownership Act. And I've continued that involvement in 116 through the State Bar Nevada, Community Associations Institute, and also the Commission for Common Interest Communities and Condominium Hotels. And I'm currently a member of the Department of Business and Industries Task Force on looking at better legislation in NRS 116. Although my materials include a number of suggested amendments to NRS 116 based on amendments to the uniform law that were made in 1994, 2008, and 2021, what I'd really like to propose is a better way of legislating in NRS 116. There are many stakeholders and different interests involved in common interest communities: homeowners, board members, developers, lenders, the real estate division. There are also the professionals who work in the area: lawyers, accountants, community managers, insurers, reserve study specialists, title insurers. Amendments to or additions to 116 proposed during the legislative session generate an enormous amount of interest, which really, and the 120-day set time period is really not enough time to properly evaluate changes to the law. What I suggest is that the legislature create a task force of some kind composed of all stakeholders to address concerns and proposals for changes to NRS 116. My own experience in this was a task force, a working group created by Attorney General Cortez Masto following amendments to the foreclosure laws in 2009, I think, that created a significant problem in foreclosures. The Attorney General gathered together a task force with all the stakeholders, and the result was consensus legislation that passed early in the session without opposition. And I think if the legislature could come up with some kind of a process to address this dealing with 116, it would be beneficial for everybody, especially legislators, since committee hearings involving 116 issues take an enormous amount of time, and really, if they could be solved ahead of time, would be better for everybody. So what we usually do in our real property legislation is propose one bill, and so we'll be working with the State Bar on what that bill is. Like I said, the most important are the recording issues that we have found, and really we're just trying to simplify ways that documents are recorded. And with that, I'd be happy to answer any questions. And I've also submitted, the materials are quite extensive, and happy to answer any questions now or later by email, however. And thank you for the opportunity to make this presentation.
Thank you so much for presenting to us this afternoon. Are there questions from members of the committee? All right, I don't see any questions here. Are there any in Carson City or online? Not seeing any. We do want to thank you again for giving us that primer on what we can expect in the upcoming session, and appreciate you being here. That will close.
Thank you very much.
That will close us out on agenda item number 10 and bring us to agenda item number 11, which is our second opportunity for public comment. Anybody wishing to give public comment in person is invited forward to do so now. Looks like we have some in Carson City. Please go ahead.
Good afternoon, Chair Scheibel, Vice Chair Miller, and members of the committee. That was interesting what he was talking about, and something he hasn't, nobody has touched on. I just want to bring it to your attention really briefly before I wanted to get into what I really wanted to say. When you're looking at this, look at reverse mortgages and how the recording works there. Example, my mother had taken a reverse mortgage out back in the early 2000s. In order to do that, everybody has to be 62 years of age. I was not. My name was removed from the title. She passed away in 2011, and in 2017, I get notice that I'm being sued because the recording wasn't done properly. And so I technically owned part of some property, and I technically didn't own part of it. The bank did. And so it kind of puts everybody in a quagmire kind of a situation. So that's something I think maybe you might want to look into. Now I'll go back to the original, what I wanted to speak of. Can't read my writing. I wanted to mention one other thing about, after we had submitted the materials, we did a comparison with Mr. Klein's case and others who had been wrongfully convicted in Nevada. And there were some similarities between his case and those who've been exonerated here in Nevada. And there's no doubt in our minds that if Mr. Klein had not passed away, he definitely would have filed for a petition for factual innocence, and no doubt he would have been exonerated. And so we'd like for you to think about that as well. I hope that you look at the information we've provided to you. It was a PowerPoint. And the reason I was speaking earlier that Ms. Grant was going to be on the line to talk about that. She would put the PowerPoint together. She's coming in July. If we are going to have a presentation, we don't even know. But just in case, I really suck at doing anything technical. So if there was a PowerPoint and it came in August and you want to do a presentation, I might screw it up. I'm just going to give you a warning on that because I'm bad at technology. And I think the good point too, I'd like to bring up, I'm kind of excited about it, don't know, but I've been approached and we have that nonfiction book to prove his innocence. I've actually written the screenplay, and that's actually what Ms. Grant was working on, was getting into the formatting. It has to be done at the end of the month. So there is an interest in a screenplay of a movie or possibly a series of our To Prove His Innocence. I just wanted to let you know on that. Thank you.
All right, thank you so much. I don't see anybody else coming forward to give public comment in person, so we'll go to the phone lines. Anybody on the phone for public comment?
Thank you, Chair. The public line is open and working. However, there are no callers at this time.
All right, then that brings us to the conclusion of our meeting for today. We will be back again in July, and we hope everybody has a wonderful month between now and then. We are adjourned.